Yeah, boom. Hoss long until Rob starts the stream. So happy Friday, folks. Welcome to Friday Night Frenzy, a show where we break down some of the stuff that happened in the law throughout the week. I am joined, as usually is the case, by a very pleasant Canadian criminal defense lawyer with lovely silken gray hair, two wonderful puppers that I call clients. Ian, how you doing, bud?
I am rocking the flu, so I'm here for however long I'm here, basically.
You're here. Well, I think that there's some shenanigans that you're going to like to chime in on, things that I haven't really previewed for you yet. So I know it was an eventful Friday. My gosh, I know we've been covering the Karen Reed trial. We've covered the Sarah Boone case. We've been covering Alec Murdaugh, but we also have been kind of dabbling in the Judge Glanville, YSL Young Thug. And we've been, what am I thinking of? What's the other one? There's another one. It will come to me at some point in time, but my brain is just not braining right now. But all of that happened. And then today we got a bunch of developments in every single freaking case that we're covering, as well as some Supreme Court decisions and opinions that are pretty ground shaking. So I kind of wanted to start with, I'm being told right now that something is disabled, so I've got to go back in.
I mean, Chevron Deference going is kind of a big deal.
Just a bit, right?
And now, for those who are not aware, Chevron Deference has nothing to do with gas stations.
No, but it did have to do with Chevron, the company.
Yes.
So, that was why. For some reason, the last time that I had streamed, I had turned off. That's what it was. Remember last week when I was trying to play catch up and I turned off all supers?
Mm-hmm.
They were still off.
Oh.
So that has since been corrected. So I was just, my mods pointed that out to me. All right, Chevron Deference. That's actually kind of where I wanted to start, oddly enough. Chevron Deference going bye-bye was, and a lot of people are big mad about it. I'm not.
I've seen that.
I am very, very, very happy with this decision, and I'll explain why. So Chevron Deference is taught in all U.S. law schools. And Ian, do you guys have a similar, I guess, concept?
Sort of. We've got Vavilov with the standard of reasonableness that, but that's only for interpretation of regulations as opposed to them making regulations. So
it's a combination. So Chevron Deference, and I will explain this via the court opinion, and I'll explain why I think it's really important that this decision was reached and why it was a long time coming. As we get into the merits of it, give me 1 second, make sure I've got this thing there. Pull up on screen. Yeah, we're getting right into topics tonight because, my gosh, there's so much to cover, and this is probably one of the most significant and impactful decisions that was made by a Supreme Court in a long time. And like I said, I think it's a long time coming. So here we go. The court granted certiorari in these cases limited the question of whether Chevron U.S. versus Natural Resource Defense Counsel should be overruled or clarified. Under the Chevron doctrine, courts have sometimes been required to defer to, quote, permissible, end quote, agency interpretations of the statutes those agencies administer, even when a reviewing court reads the statute differently. In each case below, the reviewing courts applied Chevron's framework to resolve in favor of the government challenges by petitioners to a rule promulgated by the National Marine Fisheries Service, pursuant to Magnuson-Stevenson's Act. There's the Act site, which incorporates the Administrative Procedures Act. So the holding, not to hold people too long in suspense, this is why I like some of the Supreme Court decisions, because the syllabus is right up front. Okay, so held. The Administrative Procedures Act requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts may not defer to an agency interpretation of the law simply because a statute is ambiguous. Chevron is overruled. Article 3 of the Constitution assigns to the federal judiciary the responsibility and power to adjudicate cases and controversies, concrete disputes with consequences for the parties involved. Framers appreciated that laws judges would necessarily apply is in resolving these disputes would not always be clear, but envisioned that the final interpretation of the laws would be the proper and peculiar province of the courts. As Chief Justice John Marshall declared in the foundational decision Marbury v. Madison, is emphatically the province and duty of the judicial department to say what the law is. Oddly enough, I always think this is funny. Where does that come from in the Constitution? It doesn't. It's constructed based on how the articles of the Constitution are linked. In the decades that followed, when the meaning of the statute was at issue, the judicial role was to interpret the act of Congress in order to ascertain the rights of the parties. The court recognized from the outset, though, that exercising independent judgment often included according due respect to executive branch interpretation of statutes. So what are we talking about? What was and is the Chevron deference? And this is kind of where things started to go a little haywire. So during the rapid expansion of the administrative process that took place during the New Deal era, right, the court often treated agency determinations of fact as binding on the courts, provided there was evidence to support the findings. But the court did not extend that deference to agency resolutions of law. So under this framework, what we basically have is we have the legislature who goes in as an act and body of the political will, right? We have the ability to go out and vote for either our congressperson or our senators. Their responsibility is then to go enact laws that are representative of our collective political will, our desires, what we think is proper and not proper. They're tasked with this is the law, and this is how we're going to hold people accountable. Well, some of those laws actually kind of recognize that there would have to be an agency, something that would be there to enforce the law. Because the executive branch, I mean, if they were just left unmitigated to create the agency, one, they really couldn't because they didn't have the power of the purse. They couldn't go out and independently fund these agencies. That had to be from the legislature. So we created these administrative agencies to go and do the things, the Federal Trade Commission, the Federal Communication Commission, SEC, the EPA. I mean, go down the list of Washington agencies, federal agencies, and just every single one of those agencies was created by an authorizing statute. So the legislature said, we as the legislative body of this United States, we believe, based on the votes from those individuals that put us in office, that this is important to our collective well-being, and therefore we're going to pass this law, create this agency, and fund the agency to do this thing. And the executive is then tasked with carrying that out. Okay, so the agency is created. The agency is then a branch of the executive, and the executive is now charged with carrying those things out. However, legislatures are, one of the biggest jokes that's told in all Supreme Court arguments is that we assume the legislature knows how to craft a statute to do a certain thing. Anyone that's ever read statutes knows pretty damn well that's kind of yes, kind of no.
Yeah, I'm seeing a lot of people online going like, well, this is, taking things away from the experts. And I'm going, do you really think that any of these people are actually experts?
For me, it's actually less of that. So what ends up happening is it's not just the aspect of the expertise of the agencies, because the agencies can still promulgate rules. They can still create the rule. But it's the deference that we give the agency in the interpretation of what rules they can and cannot create. Let's take the EPA for the example. Clean Water Act is one of my favorite ones to use. Clean Water Act gives the EPA the authority to regulate navigable waters of the United States. Well, what is a navigable water of the United States? Oddly enough, guess who gets to define that when the statute doesn't say? The agency. So if the agency wants to affect something, and EPA More famously, last term, I think they had a case where they were regulating essentially a drainage
For
ditch.
the chat, if I see the chat going like, why does this matter? Well, let's say the EPA decided that your bathtub, when full,
That's where I was going. That's where I was
was
going.
a navigable water.
Yes.
And then you're like, I want to challenge this. You take it to court because you're like, obviously the EPA shouldn't apply to my bathtub. And the court would just say, the EPA gets to decide. Sorry, our hands are free. Our hands are tied. Whereas instead, now the repeal of Chevron deference means that the court can say, yeah, it's pretty obvious that your bathtub is not actually a navigable waterway, and therefore they should get out of your bathroom.
Let me give you a great example of this, because Ian actually just pointed something that's actually kind of in line with the case the Supreme Court heard last term. Let's say that I'm a farmer in the Midwest, and as a part of the property that I have, this massive acreage that I have where I farm, there's a ditch. Okay, there's a ditch, just a ditch. That's it. But that ditch during a 100-year storm, which happens every 100 years, fills with water. And when it fills with water, well, water goes places, it does stuff, right? But there's really no proof as to where it goes. There's no demonstrable evidence as to where that water goes at a 100-year period. But the EPA comes in and says, well, Mr. Farmer, we have a regulation in place that says that you have to install this mechanical device, okay, to manage and mitigate water runoff, and it's a ditch, right? And the farmer's going, wait, hang on, this is a ditch. There's no water in the ditch. And the EPA says, but yes, we have defined this as being included in navigable waters. Okay. And the problem that we run into is that once the EPA has issued that definition and the EPA issues an edict and the EPA says, Mr. Farmer, you who have this ditch on your property, yes, we don't have any demonstrable evidence that the water flows off into another state or touches interstate commerce in any fashion. But because this ditch could potentially hold water and you have not installed this thing, we're going to fine you. Farmer says, okay, no problem. What are you going to fine me? $100? Now we're going to fine you $10,000 a day. The farmer is going, well, I don't have the money to A, install the thing you're telling me, and B, pay that fine.
And I can't even fill this in fast enough to avoid going bankrupt.
Yep. So the farmer wants a court to review it. And the farmer says, I don't really trust this EPA process that you did because you've just gone through this arbitrarily. I didn't have the right to be present during this discussion. I didn't have the right to put on evidence during this discussion. You guys just decided this and started hitting me with fines. So I want a court to review it. Goes to court, files a lawsuit, gets in court, and is now sitting there going, and the court says to him, well, Mr. Farmer, I'm sorry, but even though what you are telling me is completely logical, that this ditch that you have on your property can only possibly hold water every 100-year storm, I have to defer to the EPA to decide what they are and are not allowed to regulate. And here's the problem. This has happened with every administrative agency, whether it be the IRS, FTC, FCC, etc., since their creation. They are then allowed to define the scope of their own power, and the courts cannot review that.
And of course, when they define the scope of their power, it's never small.
It's always and more. So what happened was, and here's my big issue, and here's the issue I always had with Chevron. Yes, these people are subject matter experts, we assume. That's why we create the administrative bodies to do this stuff. They have the expertise. They get to decide what's important or not important. They get to decide how they want to regulate it within the confines of the statute. But remember what I said before, the legislature, your elected politicians, are the ones that tasked them with this process. And how the legislature acclimates, well, they get voted back into office or not voted back into office. There's a response to the political process. If you're disappointed with how the EPA is doing something, or if you're disappointed with how a law reads, you either talk to your congressperson or senator, or you, en masse, don't vote for them and vote for the other person. And they are responsive to the people that they're regulating. but administrative agencies aren't. There is nothing within those administrative agencies that allows for this dialogue between the citizens and the agency that's regulating them. So you've created a disconnect, which is why people call the administrative state a fourth branch of government. And this has continued onward and onward and onward like a domino effect, where Chevron might have had a wonderful meaning at the very outset, but was used to such a great extent that it became ridiculous, like the farmer with the ditch. But the court was always afraid of it. They never wanted to touch it. Even though cases have been begging for this decision, because once the Supreme Court weighed in on Chevron, every other lower court was stuck by that. They could not, they were bound by precedent where no matter how ridiculous the thing is, they could not even review it. They couldn't take a look.
And there were plenty of cases where lower courts would say, this is stupid, but we're stuck.
We can't. Yes. And
you
that's
know,
the problem.
We would love to give this person a remedy, but we're stuck with this stupid rule until the Supreme Court, unstupids it. So please unstupid it, Supreme Court.
Yeah. And the number of opinions that were offered or have been provided throughout the history since this case was resolved, Chevron, where the court has told litigants, people before them, yes, this is stupid. No, I can't touch it, is astronomical. It's ridiculous. Some of these opinions that you read are just borderline insanity. And there's no response. There's no one that they can get to adjust the insanity because the court can't look at it. So you have an entire branch of government, the judiciary, who's tasked with deciding these cases and controversies, who's basically taken out of the entire loop. So that's why a lot of people were very frustrated. And this is also part of civil procedure law that's remarkably confusing to most people. Because when you learn about how the court process should work or how government should work, you have the executive that carries out the law, the legislature that writes the law, and the judiciary that enforces the law, right? But then a law professor comes and tries to teach you Chevron, and you're going, so the legislature now gets to create a body that the executive can enforce, and in the process of enforcing that, the executive branch now gets to legislate and adjudicate? How does that work? And the law professor says, well, you're just not smart enough. So this is where this opinion came in, and Chevron is now dead. Chevron is now gone, but it's not gone for every single case. Historically, it's been essentially preserved where, hang on, here we go. The deference that Chevron requires of courts reviewing agency cannot be squared with the APA. Chevron decided in 1984 by a bare quorum of 6 justices. By the way, in this decision in Chevron, only 6 actually heard it. 3 had been not seated or had removed themselves from it. So literally it's just, you guys all decided, but we didn't really have a full hearing, yada, yada. It's kind of a little bit of shade thrown by the court here. Question in the case was whether the EPA Environmental Protection Agency regulation was consistent with the term stationary source. So something as simple as a phrase within a statute that says stationary source. So to answer that question, the court articulated and employed a now familiar 2-step approach. The first step was to basically say, did Congress speak directly to the precise question? Basically, did they define it specifically? If Congress is clear, done. So we are allowed to basically, if Congress is clear on their mandate and gave us a clear definition, we're allowed to basically kick those regulations that are inconsistent with that out the door. But if Congress was not clear, which they have increasingly become unclear because it's laziness, it is absolute abject laziness. They're more interested in sound bites than they are in their actual purpose, which is writing law. So if they're ambiguous. Yep.
The other place this comes up all the time is with the ATF, because
Second Amendment issues, yes.
yeah, they'll decide that, for instance, like a little piece of plastic or a little piece of metal is an entire gun, because they're like, we would like to regulate this. Congress isn't regulating it, so we're just going to decide that it's a gun so that therefore we get to. And that is not really how things should go, right? So, yeah.
Yep. So when the statute is silent or ambiguous, now this part always scares the hell out of me. Where the law was silent, one, my red flags are going off like crazy. If the law is silent on a thing, why are you filling the void with something?
Yeah, the law is silent because they didn't mean to regulate it. Like, if the law doesn't ban something, then it's legal. So,
and
that's
I
kind of important, right?
See, in culparistic, this is the question that people are now freaking out about. A lot of questions, and it's about agency interpretation. So now the court decides what a pew-pew is. Not really. No. It just allows the court to review the administrative decision. So the ATF can still write their definition. They can make their rule. They can say this is what this thing is. And they still have the ability to enforce the rulemaking process. But it allows for participants in the process who are being regulated to challenge those rules and say, no, in this instance, what you have said is wrong. A lot of times when these agencies are regulating people, let me tell you, the Department of Transportation is one of the big ones too. Department of Transportation, there's a lot of very arbitrary rules. Remarkable. But when you have someone who's built a road or built roads for their entire existence and has a certain subject matter expertise in building the damn roads, when you have a DOT, Department of Transportation bureaucrat, that comes in and says, nope, our rule says you got to do it this way. And the person is looking at them and saying, it's not possible. What do you mean do it this way? I've built roads like this for 60 years. I know the ins and outs of it. I know how it's made. I know it's built. And DOT comes in and says, sorry, this is what our manual says. That person who has done this, who has an expertise in the field, now is basically stuck with that decision. Can't have it argued by a court, can't get independent review, can't do shit. They're stuck. So this is what's, there. So when it's silent, where was it? When it's silent or ambiguous with respect to the specific issue, a reviewing court could not simply impose its own construction on the statute as would be necessary in the absence of administrative interpretation. So basically, the law be ambiguous. It doesn't say one way or the other. But we as the court can't even hear argument by one person or the other as to what it should or should not mean. Instead, the court had to defer to the agency if it had offered a permissible construction of the statute. Look at that, permissible. Basically, it could be the most boneheaded thing, but if it was somehow in line with maybe an interpretation of the statute, we can't touch it. So, although the court did not at first treat Chevron as the watershed decision it was fated to become, yes, they didn't foresee how big the administrative state would become. The court and the courts of appeals were so soon routinely invoking its framework as the governing standard in cases involving questions of agency authority. Yeah, the courts just kicked these cases out, left, right, and center. Bona fide cases, disputes that they should be resolving, kicked them out. It became too easy for the courts. So this is what I'm talking about. Laziness. Judicial laziness, legislative laziness, intellectual, laziness. You have the legislature who's not putting in the work to draft the statute and make it right. You have the judiciary that's like, well, we don't want to do that. We don't want to have to deal with this if we don't have to. So why not just rely on this thing that says we don't have to decide it? So there's no accountability anymore. Chevron cannot be reconciled with the APA by presuming that statutory ambiguities are implicit delegations to agencies. That's the big part here. You can't simply presume that an ambiguity in the statute means the agency gets more power. So Chevron is gone, and now we have more accountability for the people that are in Congress and more accountability for the judges that hear these cases. That, for me, was a really big thing, because I have seen that applied in some of the most ludicrous cases you would ever freaking imagine. It is asinine. Like, I hate to even say this. Let's say that an agency that's focused on occupational health and safety
And I saw somebody in the chat pointing out that there's all sorts of people who don't like this, Chevron deference, including, big companies. And the thing is eliminating this doesn't mean that you can't have rules. It just means that the rules need to be passed by actually accountable people.
Yeah.
So,
and if an agency interpretation, if the agency comes and says, we interpret the rule to be this thing, that you can actually challenge that interpretation in court. How asinine is it that an agency comes and says, we have this power because we have this power? And you're like, no, I don't think you do. And you go to court and you say, I don't think they have this power. This doesn't make sense. And the court says, well, they said they have the power. So, sure, they've got the power. What are you talking about? And a lot of people are upset, because they're like, Congress who's in the pockets of everybody else. Yep. And that's where you hold them accountable. They don't get to offhand that responsibility to this bureaucratic state. They don't get to basically say, that wasn't my call. I didn't mean it to be that way. They're interpreting the statute this way. Yeah, no, we get to hold you accountable for that. So legislatures, do your jobs. That's the thing. If you don't want to do the job, don't run for office. So that was the Chevron getting the boot, and a lot of people are either big happy or big mad. I am in the camp that is kind of relieved that a lot of really poorly reasoned decisions will at least get review. Come on, guys. I mean, think about it this way: at least getting review. At least getting the right to challenge and present your own damn case as to why this is or is not the proper interpretation. You get your day in court. That's what you get. So, and people are going to have a lot of opinions. Let's just see how the courts interpret it. Supreme Court came down. They were 6-3 on the issue. So, it's gone. People who have there's big money that has a lot of interest in this thing being gone. There's also a lot of unions that are happy that this is gone. There's also a lot of workers that are happy this is gone. A lot of fishermen, a lot of farmers, a lot of individuals that somehow engage in a course of conduct in adding and contributing to society that ends them in federal regulation that they're no purpose in being. Like, what are we talking about? So, yep, that was just, I want to touch on that briefly. And catching up, just because, thank you. Don't forget to like the stream on your way in and subscribe and jingle the bell. Yes, please do. We don't talk about Supreme Court cases a lot. I read them all the time, but I don't really like talking about them that much. I like the intellectual back and forth of going through and listening, but yeah. Good evening. Thank you, Stuart. Just because, gifted memberships. Thank you. Linda Shell, thank you for becoming a member. Lena H, finally time for FNF, a little bit late, but we're here. Michelle, thanks for becoming a member. Rachel, thanks for becoming a member. Krista Bolster Robeshad, thanks for gifting memberships. Tawny, thank you for gifting memberships. Tracy Sires, Tara Boone representing herself. Yep, probably get to that one shortly as well.
I'm sure that's going to go just fine.
It's going to go swimmingly. Fiona W, thank you for gifting memberships. DSN, thank you for gifting memberships. I talk about Bruno, thank you for gifting memberships. DSN, thanks for my membership. Thank the people that gifted it to you. The girl with the animals, love filling my time at work with F&F. Thank you. Glad you're at work. Hope you're having fun. Make that money. Dina Kawaji, thank you for getting memberships. Mountain Princess, 1 year of membership. Thank you very much for being here. Love having you here. Ian Paler, Kurt, required for this one, RIP Chevron. I know that Kurt was, I caught some of his singing earlier today.
I think Kurt might be a little in his cups for celebrating this one.
Well,
I think he opened a bottle of champagne.
The man knows more about constitutional law and constitutional history than I think any of us combined. And yeah, that should tell you something about his celebration and whether it's proper or not. Finally, Freed Family Court was rough for me this week. I'm so thankful for F&F shenanigans. I look forward to Law and Lumber and Runkle the Bailey equals pure goodness. Thank you, Finally Freed. I'm sorry you had a rough week this week. Hopefully we can make it a little bit happier. E. Warner, this made uncivil dance and sing earlier. Yep, he did. He was ecstatic. Stephanie, did you see Sarah Boone pro se shit show incoming? I did. We're going to cover it. Darlene, I'm turning 72 on Monday. Heart you both. Happy 72nd birthday. Entering that year of your life when you can honestly look at everyone else and say, oh, fuck you. I'm sorry. I think you get an FU pass after 70.
I think you get one after 7, but that's
fair. Amy T, I'm in finance, can't hope but commercial CFPB. Why is my brain not functioning? Consumer Finance Protection Bureau. Yeah. Consumer Finance Protection Bureau used Chevron deference a lot. Lena on me, love the chat. Would this apply to FDA or CDC? Yes, every administrative agency. Federal, not state. State has police power. State can do all the stuff, but federal. Britt Cormier, anyone familiar with 2A issues should know all about Chevron. The ATF defines all types of stuff as firearms when they are clearly not firearms. They do, but you never hear about it because the cases never actually get heard. Like totally. Shout out to all the EDB followers who are going through withdrawal. Also, hi guys. Yep, EDB is at VidCon. She is apparently exhausted at VidCon, but yeah. Curiously, Courtney, thank you for explaining the implications of this decision. There's so much outrage in MSM over this. I haven't been able to understand it. Chevron deference could be, well, it very much is its own like 3 weeks of law school where they're trying to teach this stuff to you. It's that complicated. It's not, but it is because of how it's been used. Jam. Hey, Law and Lumber fam. Love to you all. Thank you, Jam. Crazy Cat Queen, 12 years ago today, my CMDR and best friend, Lieutenant Roy Tisdale, was taken at Fort Bragg by one of our soldiers, can then turn the weapon on himself. Save neither. Please raise a glass with me for Roy Levo Tisdale. Strike twice. Cheers for the service that you gave, and may your family be at peace and find peace in their life going forward, and your friends who were deprived of your glow and light in their lives. So cheers to you, sir. Bop it. A challenge that a company is defined as a person. That's fine. You can challenge that. Rick Cormier, write tighter laws or pass expansion of currently enacted laws. The administrative deep state should not be allowed to expand itself. As of this moment, I am trillionaire because I passed it as a regulation. Regulations will always be and are necessary. But creating regulations that are not subject to judicial scrutiny for whether the regulations are appropriate or not, or appropriately applied or not, that's where I have a big problem.
Yeah, that's where you start getting the weird things where it's like, all right, why are we defining this, random object as so? Yeah.
Kirsten, thank you very much. The squid. So does this mean the FMCSA, I'd look that up, the Federal Motor Carrier Safety Administration, can finally be legitimately challenged in court, or is it still exempt because of commercial driving still doesn't fall under the Fair Labor Act? If it is, basically anything that is subject to the Administrative Procedures Act. So all administrative bodies created by Congress, federal administrative agencies, are subject to this decision. Aaron Sklomick, want to say thanks. My grandfather died at the beginning of the month, and it really hit me hard. You guys have helped in times my introverted self didn't want to be alone, but just couldn't people. Aaron,
I'm
glad
sorry
to hear
for your
that
loss. We helped, though. Yeah.
I'm sorry for your loss, but I'm glad to hear that we helped. And like you, I listen in to my friends online, Ian, others, Emily, Rick, Alita. I mean, pick your poison. I listen to them because my introverted self doesn't want to people at all. My introverted self doesn't want to people at that time too. So same. SF, Kurt, super happy when this ruling came out. Oh yeah, he was. Has best Friday Legal Byte stream in the morning, and Ian and Rob in the PM. Yep, I know she does her members only stuff in the mornings. Mark Safe from Lolly's Boredom gifted 5 memberships. Thank you. Kenny PA Sue Google Maps for hiding a secret sauce of water with a bridge. What, if any, side quests are we sort of on? 1, phenomenal username. 2, great trolling question. I don't usually like the trolling questions. That's pretty good, though.
I mean, that's just funny trolling. That's
peaceful. Shannon, thank you for getting your membership. Ashley, I graduated this spring and just finished my first week of first full-time job. Hopping in to say hi before I go out to celebrate. Hi, Ashley. Congratulations. Celebrate responsibly, but fully. Good for you. Full-time. That's awesome. The Squid. I graduated this spring and just finished my first week of Squid. I asked about FMCSA because as a truck driver, I'm tired of companies not being required to pay overtime. The FMCSA artificially limits the amount of money we can make by limiting the hours we can work per week. Interesting. If they have that regulation, that might now be subject to challenge. Now, here's the thing. If there were cases that predated this, the Supreme Court was very clear in this one. We are not overturning any of the cases that relied on Chevron in the past. So we're talking prospective. So if the FMCSA does something prospectively, makes a new rule, then that might be subject to challenge. Okay, so let's swoop to read. And read stuff. Swoop. Well, we don't have a verdict. We do not have a verdict. But we have some things to talk about as far as instructions to the jury at this point in time. So I want to play this little bit here, and then we'll talk about a little bit more, but give me just a second to get this going.
On 22.
Can you hear that, Ian?
Yeah, I could hear it.
Got it.
117, the Commonwealth versus Karen Reed.
Okay. All right. So, counsel, you're aware of.
I like her heavy sigh there.
Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict signed by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
So it's interesting that the defense wants the mistrial.
I think no, the defense wants an instruction. We'll talk about that in a second. And
well, the instruction gets you closer to the mistrial,
but not the specific instruction being requested. I went back and listened to this, and I actually pulled up the Massachusetts specific instruction, not just the General Allen charge. So
yeah, but the thing is that after they give it, they get closer to the mistrial declaration.
Well, let's explain that when it comes up. Well, because I think that you and I are both going to have some pretty interesting opinions on that one, because I know that I have opinions on these instructions at all after the jury begins deliberations, and I think you probably do too, as far as I don't fully believe that they're appropriate. So let's listen to the arguments being made, and we'll explain why they're being made.
earlier this week, they've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tui Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
All right. Thank you.
I'd say
Christine
that's
Eddy, I'll hear you.
splitting hairs just a wee bit.
Just a bit. I mean, did you hear the way it was explained? After an exhaustive review of the one, good for that juror for articulating in that fashion. Like, good for you. But two, that's kind of, yeah.
I would disagree with Mr. Lowry's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. This is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last 3 to 4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there.
Okay. All right. So you all know that it is within my discretion. I decide. So a case that has been, it's a long case. This is our 4th day of deliberation.
Come on, don't spinning wheel, Judge.
Spinny wheels.
No spinning wheel, Judge. I agree with her on this call, by the way.
But Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit. And this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex.
74 witnesses. How many were called by the defense? I think it was 5.
I mean,
a lot. It's a lot. It was a trial that spanned what? 7 weeks, 8 weeks, 6.5 weeks. My brain is, yeah. So now here's why we're arguing about this. Give me 1 second. We'll get through the rest of her statement. Then I'm going to pull up the Massachusetts model instruction in this regard and explain why these instructions exist and what's going on here.
Complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I am going to send them back out. We'll bring them in and we'll do that now.
All right, so she sends them back out. Let me stop sharing this one. Go to this. So when a jury is deadlocked like this, generally speaking, the jury gets what we call an Allen charge. What's an Allen charge? So an Allen charge itself is essentially
sort your shit out instruction.
Kind of. And you can see how impactful these instructions are based on how it's colloquially used. Also refers to as a dynamite, nitroglycerin, shotgun, or third-degree charge. It is in many cases what's called kind of the nuclear option before they actually find that the jury is hung. I hate Allen charges. I hate them. I think
By the way, chat, when he says finds the jury is hung, he's referring to that they can't agree, not the other thing.
Yeah, they can't agree. Yes. So they're controversial because many, not just some, many claim they are overly pressure parts of the jury to change their opinions or cave to peer pressure, especially minority opinions. This script kind of flips. Okay. So we'll read the charge and we'll explain why it's a problem. So here's some model language from the Ninth Circuit. And mind you, the Ninth Circuit is probably going to have one of the more defense leaning of these instructions. Members of this jury, you have reported that you've been unable to reach a unanimous verdict in this case. I've decided to suggest a few additional thoughts to you. One, I have a big problem with that. I have decided as the court to suggest something during your deliberative process. That's that I have an issue with. Now, these are permissible. So, as jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict if each of you can do so without violating your individual judgment or conscience. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and change your opinions if you become persuaded that it is wrong. Should you not, however, change an honest belief as to the weight of or effect of the evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. I also remind you that in your deliberations, you are to consider the instructions that I have given you as a whole. You should not single out any part of any instruction, including this one, and ignore others. They are equally important. What I have just said is not meant to rush you or pressure you into agreeing on a verdict. Take as much time as you need to discuss things. There is no hurry. I ask that you now return to the jury room and continue deliberations with these additional comments in mind. Let me tell you why. Well, hold on real quick. That's a light version of that. The other version of the Allen charge basically says that the process of going to a trial and bringing the matter to trial comes at the great cost to both the prosecution, the state, and the defense. So they basically put in the mind of the jury that there was a whole lot of work that was done to get in here, so you can't just shrug and say, not our problem. Where I have an issue with this is that, let's say that you're in the mind.
That is exactly the thing we should shrug and say, not our problem about. Oh, it cost a lot of money? Tough shit.
Yep. Here's where I have a problem with this. Notice that there's no assessment of the respective burdens of the parties in that. So let's say you're in the minority and your minority is of the opinion, the person that's there, let's say it's 11-1. And let's say the one person who's the holdout is holding out for guilt. Okay. And they believe firmly that guilt was proven beyond a reasonable doubt and to a moral certainty. All right. So this charge then asks them to reassess whether that's been actually done. But it does so when they're reassessing it, having come to the conclusion of guilt, they are now reassessing in favor of how the burden should play out. They're reassessing that on the understanding that the prosecution has the ultimate burden to prove beyond a reasonable doubt all charges, and where there is reasonable doubt, that must mean acquittal. Now flip the script. Let's say it's 11 for conviction and 1 for not guilty. That person who cannot in good conscience agree, mind you, these decisions in Massachusetts have to be unanimous. That person who's holding out and saying, I cannot find the prosecution prove this beyond a reasonable doubt, is now being asked to reassess whether that doubt itself is reasonable. I think that places a thumb on the scale. So I've never liked the Allen charges, but we didn't hear the Allen charge. The Toohey charge is what we heard discussed. And this is what that instruction is. Have you seen this yet, Ian?
Yep. I mean, if it was up to me to change things, I'd probably change it such that if the jury does hang, I'd probably say if it's not at least 4 jurors out of 12 looking to convict, that hang just is treated as an acquittal. It's like, sorry.
But As Andrea Burkhart pointed out earlier, Andrea Burkhart, by the way, if you're not following her on Twitter for explanations or following her analysis on these cases that she covers, you are missing out. As Andrea pointed out, the judge can't pull the jury. Polling the jury or asking what the split is specifically delineates the minority.
This would be only when they're saying it is over, it's hung. Now we're going to pull the jury, because the reason why you can't pull the jury midway through is because it, it can put pressure. It tampers with the process. Whereas once it's over, I see no issue with why you couldn't just say, okay, now we're going to,
Yes.
Like now,
I mean, think about that. You're mid deliberation and the judge intercedes and says, well, what's the split? And let's say that you are that one holdout or that you are two holdouts. And now you have been asked almost to explain yourself to the judge as to why you're holding out. That's nope. Even the suggestion, completely inappropriate. So you can't pull the jury and figure out how the split is right now until they've declared the mistrial, if they get to that point. But this is the instruction that they're allowed to give in Massachusetts. This is the model instruction. So at the end of the day, today, they were still deadlocked. Judge didn't declare a mistrial, didn't give the instruction, said, go home, clear your mind, come back on Monday. So we haven't got the instruction yet, but this is the instruction that Massachusetts model instruction says you should give when the jurors cannot agree. Our Constitution and laws provide that in criminal cases, the principal way for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking, in all cases, absolute certainty cannot be attained or expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusion of the other jurors. So similar language to the Allen charge. Still, in order to bring 6 minds to a unanimous result, you must examine the issue. Now it's 12 in this case. You must examine the issue you have to decide with candor and with proper regard and respect for each other's opinions. You should consider that it's desirable that the case be decided. You should consider that you have been selected in the same manner and from the same source as any future jury would be. There's no reason to suppose that the case will ever be submitted to 6 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clear evidence will be produced on one side or the other. With all this in mind, it's your duty to decide the case if you can do so conscientiously. Hang on. This is model instruction from the 2s. Give me one sec. Mass model. Did I pull? Give me one sec. Model. Crim model. Yeah. So this must be misdemeanors. Misdemeanors must be a 6-person jury.
Yeah, I mean, and a lot of these model instructions, you just adjust for obvious things, like that there's 12 of you.
Yeah, this is for the 6 is misdemeanor. So in order to make a decision more attainable, this right here, if you're reading through the lines, basically says if you have to decide one way or the other and you feel like you're on the fence, the law always imposes the burden of proof on one side or the other. In this criminal case, the burden of proof is on the Commonwealth to establish every part of it, every essential element beyond a reasonable doubt. If you are left in doubt as to any essential element, the defendant is entitled to the benefit of that doubt and must be acquitted. So this right here is a little bit of a thumb on the scale in favor of the defense, which honestly, if you're giving an instruction at this point, that's how it should be. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who are for acquittal should consider whether a doubt in their own minds exists is a reasonable one. If it makes no impression on the minds of other jurors who are equally honest, equally intelligent, and who have heard the same evidence, with the same attention, with an equal desire to arrive at the truth, and who have taken the same oath as jurors. So basically, why is yours reasonable when these other people's says it's not? On the other hand, those jurors who are for conviction ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment. If it's not shared by other members of the jury, they should ask themselves whether they should distrust the weight or adequacy of the evidence if it's failed to convince the minds of their fellow jurors. Now return to deliberations. So the two cases that were cited in this is Commonwealth versus Rodriguez, the Massachusetts Supreme Court case, and Commonwealth versus Toohey, Massachusetts case. So these are Massachusetts instructions. That's why the Rodriguez and Toohey language is used rather than Allen. So I think this is more favorable in terms of an instruction, but generally speaking, judges don't like giving this because one, it can create an appealable issue as to when the judge decides to give it.
But only an appealable issue if there's a conviction.
Yep. Let me put it this way. If Judge Bev basically says this jury continues to deliberate for the next week, two questions come up. And neither of them are really good. One, well, let's play this out. One, Judge Bev gives the instruction. And the instruction is, in the views of others, too early and place the thumb on the scale. Appealable issue. Two, Judge Bev refused to give the instruction and instead continues to require the jury to deliberate for a full week. At that point in time, you're holding the jury hostage, and that itself, not just the instruction, that itself is compelling the jury to make a decision. Again, an appealable issue. To option three, Judge Bev declares a mistrial, which, quite frankly, based on what we've heard, Yannetti was asking for an instruction, not a mistrial yet. I think Monday he will ask for a mistrial.
It's interesting that it'd be asking for a mistrial because, you know, at the end of the day, I don't know. I think the Commonwealth might have some incentive to proceed here, and they might retry it. And the amount of money that it would take for the Commonwealth to do that is lots, but they have it. They'll just raise taxes if they need to. But for, you know, on the other side, there's limited money, right? So,
yep. That's the problem. So I've seen people all over. One, I know people had opinions about the Depp case, and there was vitriol being thrown around.
Oh, people are much angrier about this one.
Oh my God. Oh my God. It is wild. And yes, I did. People have been asking me about this all damn day. Yes, I did see the stupid video. There's video, apparently, whether it's true or not, whether it's fake or real, I don't know. I don't care.
Oh, it's fake.
I saw it. It's a purportedly Jackson and Karen Reed, and Jackson is embracing Karen Reed. It was kind of, seeing that video circulated was pretty disgusting to me. Because what does it matter? I don't care. That doesn't speak to any of the evidence that was adduced at trial. It doesn't speak to anything that was said at trial by the witnesses testifying.
Well, and the thing is assuming it's a fake video, which seems very, very likely, then really the only reason that I could see that there wouldn't be a defamation lawsuit is just a defamation lawsuit is a big pain in the ass.
Yeah. Well, and obviously, because to give you guys an example of how freaking crazy Twitter is on this issue and people and how their comments are, from like one post to the next, you see one person posting the video, the other person posting analysis of the video. So you're boom, 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 boom. Last night I was sitting there looking through this stuff, and I accidentally like hit retweet on one of them that I thought was someone giving analysis of it being fake. Nope. It was just the original post of the video. I was like, damn it. I didn't mean to do that. Because I don't care. How does any of that matter?
I mean, it's irrelevant to the trial. It might be relevant if you just dislike Jackson and you want to throw shit at him, but that's not really trial analysis. It has nothing to do with like Karen Reed's guilt or innocence. And yeah, it's kind of gross.
The number of tags that people, I just need to stop reading stuff. That's the lesson I'm learning from this. Just stop reading stuff. give your analysis and just walk away.
Oh, and the number of people who like show up and just want to make like low effort trolling, and I'm just like, really?
Yeah, I'm just exhausted by it.
Same.
Okay, let's catch up on some chats. So that's where Karen Reed is right now. The jury is still, they've been deliberating for what, 3.5 days after a 6-week trial. I don't disagree with the decision by Judge Bev not to either instruct or to declare mistrial at this point. They've had the case for so long. I mean, they've had the case for 3.5 days. And honestly, we might have the benefit of viewing this evidence with the ability to replay it over and over again. I don't know. You've seen people commenting on this trial publicly, very, very, very strong in the position of one person or the other. Right? So either she did it or she didn't do it, but those opinions have been like bedrock to those people. I am not surprised that after listening to this entire trial, people would form opinions that are very difficult to change among 12 people selected.
Oh, I mean, I commented, I was like, it is really, really likely that, if you've got somebody who's like Coffindaffer in there and somebody who's like Turtle Boy, and, in the sense of both being unwilling to change their minds and very much committed to one side or the other. I'm not comparing their analysis, just their unlikelihood of changing their mind. I think that you would very much find that there is a, how do you not get a hung jury in that case, right?
Yeah.
I mean, unless you end up with like, we 11 have unanimously voted to acquit, and it's like, weren't there 12 of you? It's like, we also need a cleanup on
clean up on aisle 5. We voted them off. We voted that person off the island. You know what? My only hope is that every juror that's back there and forming those conclusions is doing so with that standard in mind. That's my only hope, to a reasonable and to a moral certainty beyond a reasonable doubt. So let them deliberate. Let them keep deliberating. I think giving them the Rodriguez or 2E charge right now, a little premature, appealable issue. I think if Judge Bev holds them over, let's say Monday they don't have a decision, it's a different ballgame, right? At that point in time, the metrics, like you heard the arguments being made by Yannetti and Lolly. Lolly talking about meaningful time to consider the issue. Yannetti saying that it's been exhaustive. Judge Bev's instruction at the end of the day was basically not keeping the jury over the weekend, which she had the power to do, discharging them and saying, don't think about this damn case. Like, come back on Monday with a fresh mind. Now, here's what that does. If they come back on Monday after that level of instruction and after this debate and after on Monday, they go through deliberations, they can't reach a decision, I think you're at I don't even know if you get to a 2A charge. I think you immediately, I don't know. I think you'd mistrial at that point. So we'll see. So this case is nuts, and it just gets more divisive. The longer the jury's out discussing this, and you're not hearing evidence, the more and more and more vitriol you see, and I just hate that part. So let's play catch up on some super chats. Ian, did you have any final thoughts on Karen Reed?
I mean, in some ways, a hung jury is the worst possible outcome for people getting along online. Because if it ends up being a hung jury and nobody can agree at the end of it, that, and if they don't retry, then what we're going to end up with is all the people thinking, it's going to be messy, and there's going to be a whole lot of people who just want to troll and so forth. So,
I would like to see a verdict one way or the other.
As would I. I mean, there's a particular verdict I'd like to see more than the other, but
I don't think is the right. I think there's a particular verdict you believe is more appropriate and consistent with the evidence than the other. It's not a desire. Yeah.
Well, I mean, when you see that one verdict seems appropriate and the other not, you
Then
kind of hope
it's a
that's where
desire.
things
Yeah.
will go.
Yeah. So I'm just waiting to see that, but let's catch up on some of these questions and then we'll get to our next topic. Look, we're flying through 1 hour in and we've hit 2 topics. My gosh, Chevron and not Sarah Boone, Chevron and Karen Reed.
I'm too sick to really interfere, so that's where we're stuck.
I know I'm never going to wish this on you, but
the flu's helpful.
All right. So Alita Lee, happy birthday to you who turned 50 on Sunday. Congratulations and happy birthday. Enjoy every single minute of it. Bumble, been watching longer than 3 months. Love it here. Thank you. Member and for watching for 3 months. Wine Cellar Infused, thanks for becoming a member. Much appreciated. Kirsten Berry, thoughts about Reed? You just heard them. And Kirsten Berry again, thoughts about Reed. You did just hear them. We went through them. Ren W, thanks for becoming a member. Red Solo Cups of Evidence, thank you. So the Chevron reversal does not mean that SCOTUS is now the only body that can grant power to regulatory agencies. Yes, Ren thinks it does. Your friend needs opinion. Just send it. You know, honestly, it's not the hardest thing to read. It's actually pretty well written. So, no, that's not. AKA the Cat Lady, panic attack all week from Karen Reed. The fact that people, this is the other part about this. I want people to go outside, touch some grass this weekend. You cannot stake your entire happiness and self-identification and just sanity on the outcome of one particular trial. You have to recognize that this is a trial taking place in Massachusetts. Yes, it involves what people perceive to be an injustice or people believe to be a righteous prosecution, but you cannot stake your entire well-being on the outcome of this trial. You'll go insane. You hold the legal system to that standard in your mind, and you are compromising your own mental health as a result of a particular disposition of a case. You need to reassess some of those values and just take a deep breath. Go outside, hang out with friends if you want to, make something, feel better, relax. Linda Butler, IRS, FDA, both of them, yes, for the Chevron case. Brenda Plunkett, I'm going to be a grandma. That is awesome.
Congratulations.
That is so cool. After patiently waiting for 25 years. Well, I imagine the fact that you had that 25-year number there might have been some suggestions that you were offering down
some hints.
Some hints over the moon. It was a great birthday present. And you're going to be a grandma? That's awesome. Tamitha, hi, Robin and Ian. I'm curious if either of you have had a polled juror say the verdict was not their verdict. How often does this happen? What happens then? Well, I don't do my trials or bench trials because we don't put family law issues in front of a jury. Very good reason for that. But Ian, have you ever had a polled juror come back and say this wasn't my verdict?
No, I've heard of it once, and that's heard of. I've never seen it. I've never known someone directly who's had that. So,
generally speaking, though, the rule of what would happen is the judge would not accept the verdict and would send the jury back to either deliberate further or would declare a mistrial. Very likely, under that setting, I imagine that's a mistrial. Because at that point in time, you have most certainly placed that minority juror under pressure by sending them back to deliberate. So that's mistrial. Ashley English, I needed FNF tonight. Lost my grandmother last night. I'm so sorry. Held her hand as she took her last breath. She was my person. Thanks for the distraction. I'm happy to be a distraction. I'm sad and troubled. Well, saddened by your loss. And I hope you find solace and family around you and friends around you. And I hope you remember all the wonderful things about her. So it is difficult to lose loved ones. Glad that you're finding a way to decompress a little bit. Miss Jen, PhD, do you believe the defense team proved reasonable doubt? Can't see how jury sees any evidence of a murder. The defense team doesn't have to prove reasonable doubt. And but
Yeah.
here's my
Reasonable
one
doubt
criticism.
exists if nothing happens.
My one criticism of the defense in this case. When you put forth, and it's a double-edged sword, right? It's a catch-22. One, most jurors can't get over, or they can't really just rely on the whole reasonable doubt thing. They actually need an alternative. Because when you get back in that jury room, the one argument you can expect to hear from every other juror when one of them is a holdout on reasonable doubt is, well, what's the alternative? What happened if not this? Right? And I hate that. That's not how it should be, but that's how people operate. So the catch-22 is generally people want an alternative set of facts. Caveat on the flip side of that is the defense can sometimes create a burden of their own by putting forth an alternate set of facts. And the jury is now assessing whether they did or did not prove something when they should not do that in the first place. So it's the human element of juries that it gives you this kind of conflict internally. So if I had a criticism on the defense, it was that I would have reserved about 5 minutes of time of my closing argument to hammer that reasonable doubt part. Like to basically speak to the juror. Let's say that one of you goes back there and doesn't believe a single thing I just said. Now, you wouldn't say that. That's a terrible way to close. But you would basically put in their mind reasonable doubt, it means you acquit. It's a tough call, though. It's a judgment call. And that's it's Monday morning quarterbacking. Billy's Momzilla, limited commercial driving hours are safety rules, not an overtime pay issue. Thank you, Billy. Billy's Momzilla. And that's the opinion people are going to be discussing on all these issues, agency issues. Bravo Chick, 8 months. Wow, I have a question. Bev appointed a 4-person before the jury was cut to 12. Is that normal or is that sus? In my understanding, in Massachusetts, the judge appoints the 4-person. This is actually included within their model instructions. So their model instructions directs at the end of that model instruction that the judge appoints the 4-person. Sue, scares me with 2 lawyers on the jury and retired cop. We don't know who's on the jury. No way 2 lawyers will agree, let alone 12 people. We have no idea the makeup of the jury. Everyone is speculating. They might be reaching conclusions based on some information they have, but I don't know that I trust that information. Vaz from Quebec, watching from TV tonight. Love you all. Thank you, Vaz, for being here. Glad to see you here. Kirsten Berry, I live 1 town from where this case is being tried, and it's known that there's a juror who's an ex-officer and likely the 4-person at the circus. See, I am struggling to give weight to a lot of reporting on the makeup of the jury. I'm struggling in that regard. So I will take that with a grain of salt, but honestly, I don't know that it should at the end of the day matter. Billy's Momzilla, if the jury is split 11-1, not guilty, could the judge dismiss the charges? Nope. Hung jury and mistrial. They get to go again. Famously, wasn't the ice cream truck person that was a 11-1 hang, and then they retried it and he got convicted? So it happens quite a bit. K-Rab, is it an Allen charge in Massachusetts? Lolly uses a different name. Yep, Rodriguez and Tui. Language different with Allen.
It's a little different, but it's the same idea. Same
concept, a little different. Emphasizing financial cost. Yep. What, if any, side quests are we sort of on if we're not to consider the consequence of a verdict and decision on society at large, then it applies to the government as well? Not our problem. I think that is either in regard to this case or the Chevron case, but I can see it equally applied. Cindy Wilkins, thank you for the super sticker. Mickey, jury's revenge. How long can we deliberate? Could be. However, I imagine some of them will go home. I imagine some will want to go home. So I don't know if it's that. Golden Rose Tuxedo, how is someone's intelligence measured? I don't purport to know. Everyone has their own rules. Odin's Martyr, Runkle, have you considered that the red Solo cups might have contained some amount of arnica cream? Thus
Amica
fixing-
cream.
Am-
But it's actually
Arnica
arnica.
cream.
But yeah.
thus fixing the Commonwealth's case. It might be the restorative, perfect product that heals bruises in 2 seconds. SK, does the defense arguing that there's been enough time for the jury go against them if they appeal on the instruction being given too early? Kind of, yeah. They would be in a position. I mean, they'd be in a position of saying we're arguing for the instruction now. And I would imagine they would have to, because here's the thing, in order to have the issue preserved on appeal, you have to object. You have to make an objection.
Yeah.
Now,
So them having consented to it and
Means
in
they
fact
waived that
advocated for it would mean no appeal issue.
Correct. With limited exceptions for ineffective assistance of counsel, but that would be so remote and not possible here that it's not possible.
Yeah, I was going to say, good luck getting ineffective assistance of counsel on this
no,
team.
No way.
I'd be like, are you kidding?
Side note, every single defendant will argue ineffective assistance of counsel. They all do. Most of them do.
No. I mean, most
you do the
appeals are not
appellate
ineffective
stuff.
assistance of counsel.
Because it's a losing case almost 90% of the time. Cindy Wilkins, makes my Friday better while I fight last stage of pancreatic cancer. I look forward to every Friday while I'm in last stage. Always makes me smile. Love y'all. Cindy Wilkins,
Cindy, you're in our thoughts here.
you are absolutely in my thoughts and prayers. And I very much hope that you keep up the very best of the good fights. Fight, fight, fight. Don't stop fighting. Don't let it take your dignity. Fight till you can't fight anymore, and then fight some more. So, canonical heat. Cindy, cheers to you. Keep fighting, and then fight more, and then keep on doing that when you feel like you got nothing left. Fuck cancer and the horse you rode in on. Canonical heat, 16 months. The seeming length of the KR trial. Please make it stop. Sobs quietly.
It's been 87 years.
Canonical Heat gifting 20 gifted memberships. Thank you, Canonical Heat. That reminds me, please make sure you hit the like button. 4,400 of you watching right now. Hit the little like button. It does a whole lot to the channel. Please do that and consider subscribing as well. And to my friend Ian, who will be covering the Baldwin trial. And we'll talk about that briefly shortly. Diamonds and Doggies, any legal consequences for people posting Dr. Wolf, wife, and kids' pics since he's a federal witness?
Not unless there's
No.
I mean, if you posted it along with something like, teach this guy a lesson about testifying against us, by going after these people, that would get you some shit. But just posting the pictures, probably not.
Yeah.
Don't do that, by the way.
Don't do that. Let me see if there's any more Karen Reed specific. Amy's positive pathways up in Massachusetts. Everyone knows about this. How could they ever find impartial jury? It's so frustrating. All the jury doesn't see reasonable doubt. This is the process. We might object to it, but this is how this works. So we have to let this process play out. Kirsten Berry, I live one town over, and it's nuts.
I'm curious as to what sort of word on the street is over that.
Curious as well. Rich Mills, did you see Diddy's law firm dropped him because of Lady Gaga? Probably conflict of interest. Yeah, I don't know. Maybe. I hadn't seen it though, but I'll take a look.
Yeah, I'm guessing that's what that would be.
Hold ya, man. Thanks for your insights. If the case gets retried and it was your case, would you opt to have the judge instead of jury decided? Nope.
No, God, no.
No. Bench trials are notorious for being either convictions almost automatically, or it is. Nope. I want to.
Do you really want this trial to be held on the basis of whether or not it's going to get the judge reelected? Because
no way.
Elected judges plus bench trial equals Y. If it was Canada, I might say bench trial, because we don't have elected judges. So very different.
I still don't like it. I like the ability to discuss with real people who are not parsing the legal arguments, who are instead listening to the facts and letting me argue it. Yeah, I want a jury. I say that being in a field of law where we never put issues to juries. Because family dynamics, imagine trying to select a jury on a family issue. No way.
We need a jury who has never actually had a family dispute.
And I need to be able to ask that in voir dire and actually get an honest answer. How? I mean, there's no way. And I need to ask about that person's upbringing and whether think about all of the things that influence your opinion on whether a family decision is right or not. Like
this
stemming back
case
to
involves
your
infidelity.
birth.
We need to ask each of you whether or not you have
Cheated.
experienced or been on the side of infidelity, including whether you're doing that right now. So,
Oh my God.
Juror number 1, he's like,
I
no,
plead the
just
fifth?
contempt, please.
Yeah, can I plead the 5th? Yeah, no. Sassy me, why didn't we just pray for the justice to be done? That's what I'm always praying for. I hope the right outcome is always reached. Always. Kenny Peterson, Rob heard that this jury cannot read back testimony from trial. Is this right? Correct. You don't get readbacks. That varies by jurisdiction. This is one particular jurisdiction where, and the normal rule is no readbacks. Your recollection of the memory of the evidence is what is there. The reason why is it becomes unfair if you allow a portion of that evidence to be refreshed in the mind of the jury as opposed to their collective recollection of everything else. So you can't pick out pieces and highlight the pieces of evidence, even if they're asking for it. Miranda Huck, do you think the defense spent too much time on the conspiracy, not enough time explaining reasonable doubt? It's my one criticism, and I don't have many with that close. That close, it's text.
Yeah, it was a really good close. That's the only thing I could. Yeah,
and I think that's based on constraints on time. He only had an hour. I think this trial, I think he probably should have gotten 2 hours to close. I would have taken it. I would have appreciated it, but I don't think an hour is prejudicial either. It's time limits do things. I mean, look at what Lolly did. Lolly basically did a speed reading of the evidence towards the end of his trial, end of his closing. He didn't get through half his close.
Lolly was meandering a bit during his close, and he ran out of time. I don't think he practiced it.
Geraldine Friedrich, lawyer, said something about only being able to send them out twice. Then they have to ask each juror if they want to continue. That I know that Peter talks a lot, but his familiarity talks a lot about trials in Florida because that's where he practices primarily. So I know that most of the time when he does this, he caveats those statements with, in the jurisdiction where I am, this is what takes place. So I have nothing to believe that Massachusetts has anything like that. And honestly, I think that an arbitrary rule like that I don't think that's constitutional. Matt Bond, hello, my spiffy, legal, mumbo, jumbo, talkie brothers from other mothers. How I have missed thee. Matt, how I have missed you as well, my friend. Thank you for showing up and bringing all the cheer to the chat. Thank you, sir. Much appreciated.
Rob, what did you think of the argument that Lolly made that clearly Karen Reed knew John O'Keefe was dead because she didn't take her shoes off?
She knew she was never going to have the argument with him and that's why if there's places to focus your evidence, you know what, damn it, I need a minute. That's going to piss me the fucking shoes. I need a minute. I hate you. I need a minute.
Oh my, yeah. And yes, I think lawyer, was reading off the Massachusetts. I saw Andrea said the same thing. So it may just be a procedural limit. So yeah, but apparently that only gets triggered after the instruction is read, and the instruction hasn't been read yet. So I'm wondering, I'm wondering if Lally hasn't made a promise or a representation to defense counsel that they wouldn't try it again if there's a mistrial, because I'm just wondering, like,
You mean based on how hard he was pushing against the mistrial?
yeah, exact. What based on why the defense was pushing for the mistrial and Lally's like no mistrial.
Yeah, I don't know. I don't know that because that authority would have to come from his boss.
Yeah, but I mean, they could have. It wouldn't surprise me if they talked about it.
Hang on, give me 1 second because I want to read this instruction again. Alternate instruction. Expense inconvenience. Yes, it's only after the instruction, so it's a note. So there's a note at the bottom of this model instruction that says if a jury here, I'll pull it up. Let me do this. It's a good question. Thank you for whoever brought that up, and thank you, Ian, for pointing that out to me because I would have gotten something wrong. And I don't like doing that. So let's do this. Where is it? When juries cannot agree. Here's the note at the bottom. So restricting or sending out the jury more than twice if a jury, after due and thorough deliberation, return to court without having agreed on a verdict, the court may state anew the evidence or any part thereof. Ew. Really? Ew. What? Oh. I don't like that at all. For the reasons that I said earlier. Why? Why are you allowed to highlight any part of the evidence after they said they can't agree? No.
And that could be
that's
really
terrible.
That could be really funny depending on how they did it. Like Judge Canone says, hey, jurors, I want you to go back and reiterate this, but I also just want you to recognize that the two independent experts with actual training both found that this was not a motor vehicle accident. I'm highlighting that. But I mean, what they decide to highlight could be absolutely an appealable issue.
That's I think there's no way you can do this without agreement. There's no way. Because if one of the sides objects to the evidence that you're picking back out to read, I mean, think of something that's more prejudicial. Oh, explain to them that anew the law. I don't like that very much, but okay. And send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent. So you have to ask them. Unless they're asking for additional explanation. They come back out and they're like, we can't agree, but if you explain the law in this issue, we might be able to. Okay. Oh. Explaining part of the evidence? No. Ugh.
Mm-hmm.
No.
I mean, if I was going to be inclined to do that, if I'm the judge, I would absolutely be inclined to lean towards the defense when I was highlighting, just because that avoids, like, if the defense wins, there's no appeal issue.
No appeal.
Including if the judge does something really egregious to have the defense win. Like, jurors, this is obviously an acquittal. Go back and deliver. Prosecution can't appeal after the acquittal. Now, I mean, there's other things that they would do, but it's still funny.
Yeah, if you're a judge, you are basically taking that trial and almost acknowledging being overturned in a very embarrassing way. If you pull out a piece of prosecution evidence and recite it over objection by the defense. I mean, I cannot see a more embarrassing, scathing remand and reversal coming from the Court of Appeals if that's how you did it.
Yeah.
Look. Yeah, no. Froggy Girl, if they get a new trial, can they ask for a different judge? They don't get a decision on the judge that hears them. I don't think Massachusetts has automatic recusal rules no, because she actually declined recusal. So no, you don't get to decide what judge hears your case. All right, let me
Some
do
places
this.
do have some options to like let you bounce one judge.
I've got the rest of these saved, but I want to get to the next topic because people have been driving me nuts about this one in particular. And to give
Does it involve suitcases?
I pulled up the chat to show you.
No, well, I'm not watching the window. Oh, yes.
Yeah. Stephanie 1208, did you see Sarah Boone is going pro se? Brooks 2.0. Could be. Let's talk about it. Sarah Boone. Oh, Sarah. Oh, Sarah Boone. So where we left off in our saga discussing the Sarah Boone trial and the upcoming Sarah Boone trial was that essentially Ms. Boone wants her lawyer to be very nice to her, doesn't like lawyers that disagree with her, and wants a bond and wants a trial, but also objects to her lawyer and files motions endlessly. And every lawyer that has been appointed thus far has asked the court to kindly please no longer make me be her lawyer. We have covered various motions to withdraw, discussed them at length. And one of the discussions that comes up a lot during the course of all of this is, is there a possibility that, what do we do if you can't just keep appointing lawyers? And the statement that I've made in the past is that an individual, by their own conduct, even if they are not voluntarily and knowingly saying, I don't want an attorney and don't need an attorney, but by their own conduct, they can waive the right to representation by counsel or representation of counsel funded by the state. Because even though they haven't actually come out and said that out loud, their own conduct in the face of being advised over and over and over again, their own conduct indicates to the court that they knew this was a potential consequence and that that would be kind of the end of it. And the last dialogue that we had, the judge gave a very firm admonishment, just being a statement from the bench to Ms. Boone, and said, look, you understand, I can't just keep appointing attorneys over and over again, right? You don't get to just, you can choose your attorney if you pay for them. But if you're not paying for the attorney, you can't keep requiring the state to keep appointing counsel endlessly ad nauseum when the objections you have are nothing. So that was the admonishment that was delivered to Ms. Boone before she passed this letter up the same day. For those of you who can see the right side of the screen, that letter is 58 pages. 58 pages hand delivered, and the hand delivery has lovely little scrawl in bold, and everything is capitalized. Honorable Judge Michael Kranick from Sarah Boone with the case number stylized. I'm sure that she was very upset that people were reading this with a little star that says regular correspondence, legal correspondence to Sarah Boone at this particular address, that being her P.O. Box. Wait, what? Oh, that's to her attorney, I guess. Filed it up in court. We're just going to read like one page of this. There's no way I can read. Yeah, Court TV. There's no chance I can read this. There's no way. 58 pages? No, but we're going to highlight the very beginning to kind of just go with, we've heard this before. But thanks for being in the chat, by the way. Love having you here. Thanks for all the coverage of the cases and for the support of showing up in the chat for Ian all the time. So, Honorable Judge Kranick, ongoing 5 years. Why can't I ... Bullet list continues. Use my constitutional rights. Am I the only one who cares about the ongoing violations of ? That's a sentence. Have a bond. That's been explained to you several times. Have all my medical records. I think that you do. How have all my digital evidence and discovery. I think that you have it. I just think that your ability to access it might be a little bit inhibited, but you have it. Have my paperwork, notes, letters, pictures, everything of mine returned by my former attorneys. Well, they're probably passed on to the new counsel as part of the file. Speak to my investigator. Imagine you can. I think the judge actually said you could. Have a complete download of my phone. That would be discovery. Why are you focused on that, Sarah? Ms. Boone, is that because there's videos on the phone that you are really not happy about and you want to see what videos are out there before you, well, have any of my witness lists give any insight, understanding, clarification, and truths about my case, especially to my attorney? From the record, you have been able to dialogue with your attorney at some length. Now, whether they take your insight, understanding, clarifications, and truths, your words, and they decide that maybe they're not going to use them at trial, it's part of their ability to do that in assessing what case is your best case and what is your best defense. People don't often talk about this, but the defendant actually has not absolute right to dictate how their defense is run. Ian, you're aware, you know this.
It's a little different. The Canadian rule is a little different, but yeah, I mean, you can't there are certain like absolutes, like for instance, you cannot direct your lawyer to engage in unethical behavior ever.
Mm-hmm.
But also typically, I know in the States, the rule is basically just saying like, you need to, you can say things like whether or not you want to testify and so forth.
Yeah.
But the specifics of how they run their case is really up to the lawyer. So the lawyer gets a fair bit of, fair bit of control. Like you can't go and, review your lawyer's cross-examination plan and so forth. So.
Yeah. So this was actually famously put to the test in the Charles Manson case. You remember talking about that one previously. The Charles Manson case, essentially, where the lawyers were compelled to put forth a defense that their clients didn't really agree with. They didn't like it, but it was the best defense they had. And the clients had very limited rights in that regard. The right they basically had in that regard was to demand that they testify. So your participation, you are entitled to meaningfully participate in your defense. But as far as what you can direct your attorney to do, it's not absolute. There's some things you can, some things you can't. It's a little bit of a mixed bag. But she's asking again, why can't I be listened to by anyone, especially my attorneys, be respected for who I am truly, especially by my attorney, and not be disrespected for the, what is that? Something aided? Mutated? Is that mutated?
Disrespected for the
something tated? Malicious murder of the.
That's a word. I'm not sure what the word is, but
wait, she had a map in there. Sorry, Court TV. I saw your comment. She had a map in here. She has a map in here. There's a map in here. Why is there a map in here? Is there a map in here?
Is there also a file?
Wait, what? There's a map? I gotta find the map. Wait, what? Disrespect for the mutated malicious murderer all the world has falsely, incorrectly created and believes me to be. Why can't I be treated fairly, lawfully, and protected by the, quote, justice, quote, system? Interesting. Properly, rightfully, completely defend myself. Why can't I properly, rightfully, completely defend myself? Well, you now can. You can properly, in your opinion, rightfully, in your opinion, and completely, in your opinion, defend yourself. See all and know the same as the world can and does, including my attorney, from all the phenomenal non-permissive amount of my entire case being available online globally before my trial, and most important, before I have seen it myself. What doesn't anyone know already about my case? How about my side and everything about everything? Well, the thing is, you knew and have known that every letter that you give the court, because the court's told you several times, if you give us this, I file it, and if I file it, it becomes public record. So be correctly understood that I am not the problem for reasons I am malappointed by attorney number 8. See my letter 72123. We have say what I want and should, but all the world can and say it all wrong and warped. Why won't my attorney give me an honest answer? This is a whole lot. This is a whole lot. Is there a map? Is there really a map? Let's see, organized pages. Is there really a map?
Or are they mocking the Google Maps thing?
Court TV, if you are trolling me based on Google Maps, I'll be pissed. Oh no, there's a map. No.
It's a map of the United States, apparently.
No. In what context does this come up? Oh no, she's arguing. She's arguing Miranda. Oh, she's arguing Miranda. Oh my God, this is bad. The mark of custodial interrogation is the person knows the person is in custody and has no freedom to leave. I did not know I was in custody and could not leave. Your statements are also voluntary and you're not being questioned at that point. I was told by counsel to come pick up my new phone or my phone. No warning of being interrogated again. They don't have to warn you. Stakes of interrogation are higher than when a person is free to go. Were you being detained? Constitutional distillate. No. Did you really use the word distillate? You did. The constitutional distillate of Miranda is that self-incrimination flowing from custodial interrogations is pro se, is ipso facto compelled self-incrimination because of the inherent coercion, the inherent compulsion of the custodial interrogation environment. That's got to be a quote from the case. There's no way. Excited utterance. Oh, she stars this one.
I think she's got a jailhouse lawyer.
Why is there a map? She puts, did she
It's
interlineate? Are these interlineated stars? Publicity, exploitation, and saturation. No way. No way.
She's asking for a change of venue to Tahiti.
Oh my God. There's no way. Is Virginia there? Yep, we've got Virginia on the map. There you go. Wait, Ian, did you make it all the way up here?
How do you
I don't
mean?
see a star as far as coverage.
Oh, I haven't covered the letter. I read the letter.
Oh, no. We go global. Oh, wow. So that's a thing. There's a map. Court TV, thank you for the instruction. What the fuck?
I'm guessing this is like a map of where people have covered her.
It's okay.
People are saying it's covered her fan mail.
No, it's okay. She explains it. She explains it. There's a key. I didn't read far enough to know there was a key.
Maybe I should send her a
map.
letter just so I can get Edmonton on the map.
Oh, God. Publicity, exploitation, and saturation. United States map, page 1. To date, each star is a state where I have received correspondence via mail or message regarding my current criminal case. World map, page number 2. To date, each star is a continent where I have received correspondence via mail or message regarding my criminal case. The number grows daily. Most all letters and messages are available for a review and understanding of the impact of my case details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudgment before my trial. I, the defendant in my case, have not yet ongoing 5 years fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. Every one of your lawyers has said that you have access to the discovery file, like every single one.
Also, I don't have access to the discovery file.
No. What I do have access to is, the public dissemination of certain contents that were being made or being disseminated of the phone. Whether that was right or wrong, I can't opine on that, but I don't know how you can really explain the video. Yeah, Court TV, Nightbot hates the caps. Yeah, Nightbot doesn't like the caps. It's not as bad as Fightbot, but Nightbot's pretty good.
I've got to adjust the Fightbot messages to be even more aggressive.
Wow.
Just so it could be like super Fightbot.
Wait, what? My present attorney said it is, quote, not necessary to receive a court order. I've been trying to obtain to download my case information to apply from the OCCD tablets. Oh, so basically you wanted your case info on the tablets? No, they're not going to let you have that. They'll give you access to it, like to review it, but you don't just get to have that on your person at all time. Former attorneys are withholding something like, why? This is not lawful law. This is not real. Is this real? There's the map.
Rob,
There's
did
anything
you
else?
seriously just say lawful law?
I did for a reason.
Was it a good reason or just
Yeah. Because we got an order today. So we might be hearing lawful law beginning with this trial, which I think is still slated for the October trial date. Order. This cause came before the court on June 28th, 2024. Funny thing, that's today. On defense counsel Patricia Cashman's motion to withdraw as counsel, filed on June 11th. The motion. The court, having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, having considered the positions offered by counsel Patricia Cashman, having considered the testimony offered by the defendant, Sarah Boone, and having considered the positions offered by counsel for the state, hereby finds. We don't need the procedural history because we know we went through attorneys 1 through, there's 1, 2.
1 through 60.
Where's 3? Hearing was held. That was 2. The 2 went bye-bye. Then we had amended motion to withdraw. I didn't like the language of the motion withdrawal, but the court goes through the history. Here the court first states, the court advised the defendant of the state's concern regarding a strategy of the defendant being unhappy with every attorney and advised the defendant about dangers of self-representation. See, that's the court first putting you on notice and saying, don't do this. You keep doing this and you're going to end up in a place you don't want to be. The court appointed public defender, attorney number 3. So after attorney number 2, the judge was like, hey, chill out. You don't want to do this. You're not going to like where you end up. So.
But it will be hilarious.
And sad at the same time. Combination.
No, just hilarious.
Well, then there's a conflict of interest. So that's fair. So attorney 4. So we're not going to really be pissed about the from 3 to 4 because there's a conflict.
Was the conflict just we think this person sucks?
4 to 5 is conflict. No, they were actual conflicts. I don't know why, but they were conflicted out.
Due to this person sucking?
Pre-trial conference. Oh, God. They got motion to continue this trial. The point that she keeps making is that, yes, this has been dragging on. This trial date needs to happen. So,
I mean, she's not wrong about that.
I know, but stop firing your attorneys or putting them in a position where they have to withdraw.
I mean, counterpoint. Do the funny thing.
This is so not going to be funny. Oh,
I disagree.
Oh,
See, Rob, you're not
Yes.
laughing, but you're not in on the joke.
I'm just trying it because she wants to put on a battered spouse defense. Oh my God, the expert testimony. You need to put that on, and all of the foundation you have to lay. This is going to be a nightmare.
Are you
A
saying that she's
nightmare.
not going to successfully be able to
Present the
retain and
defense?
instruct experts, both with her level of talent and from in custody? I find that hard to believe, Rob.
Or that she can adequately lay the foundation to present the defense or preserve the defense, or that she can adequately question those experts or the competing experts by the state. This is going to be a so then
It's going to
Bankwitz
be a
moves to
party.
withdrawal. It's going to be wild. You guys, we've read the letters, and we've heard her talk in court. Say what you will about Daryl Brooks.
Oh, I will say lots of things about Daryl Brooks.
This has the potential of being worse.
Or
Like
funnier.
less gross feeling than the Daryl Brooks stuff. Brooks stuff, that was gross. That felt really bad. Like I didn't like the fact that he
still
was
pretty
questioning
gross.
people. It was pretty gross. But the Sarah Boone stuff has the potential of being less gross, but pretty. Nope, I take that back. It can be bad because battered spouse defense. This could be awful.
Mm-hmm.
Bankwitz had a car crash after he sought to withdraw. Then he seeks withdrawal in October. We're back in 2022. We are back in 2022. Bankwitz. So in this review hearing, court conducted a hearing, determined that the defendant was not seeking to remove Bankwitz. Bankwitz advised the court that thousands of pages in discovery that he had reviewed and organized in his contact and personal use of collaboration with expert witnesses, including experts that Padilla, attorney 2, utilized. He advised the court of defendant's attempts to call Bankwitz at a rate of 5 to 10 times per day. Bro. 5
Uh-oh.
to 10 times per day?
What, you don't like your clients calling you that often?
Dude, I start getting like hate emails from my staff when it's like more than one call. 5 to 10 calls per day. What could you possibly be? And this is like not a day that like precedes a deadline, right? Like a day before a trial, 5 to 10 calls. All right, I'll take it. That's normal. A day before a massive hearing. Yeah, I'll take it. That's normal. But on just a normal Tuesday, 5 to 10 phone calls? Bankwitz advised of his efforts to balance the demands
She's,
of other clients.
The thing is lots of clients get very lonely, I think is the word. And they want attention. And they don't really realize that maybe it's not the best use of their lawyer's time to be like, your lawyer is not really your friend.
I mean, I'm friendly. I have great respect for a lot of my clients.
No, Rob is not friendly. Your lawyer is not friend-shaped.
I can be friend shaped, but not like when I'm like in the law side. Law side, no. Your case is business. Your case, not business. Your case is something that's very important to me, but it is a case first. It's not like having a beer over like golf discussions, etc. It's your case. Bankwitz further advised of his efforts to balance the demands of other clients with the defense expectations for communication. In response, defendant, Sarah Boone, reposted that Bankwitz's representations were untruths. Well, that's one way to get your attorney kicked off is when you say, I disagree. Raise the prior public recommends for, this is going to get
It's not so much disagree. It's when you call your lawyer a liar now you need to find someone else.
Oh, and then did the magic words, which is sought to remove Bankruptcy.
Yep.
Court pointed out defendant's inconsistent statements within minutes of them being made and addressed concerns over defense motivations, especially when there is something defendant disagreed with. Oh, baby. The court specifically advised, and this is back in 2022, that she is not entitled, oh, this gotta love when the judge pulls out a quote, that she is not entitled to an endless line of court-appointed lawyers until you find the one that you personally prefer. Court also explained, here you go, put on notice, that the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Bankruptcy. The court denied the motion withdrawal and directed Bankruptcy to have a conference with defendant prior to pretrial. All right. So then has the conference, files another motion withdrawal. Just can't do it anymore. September of 2023. Bankruptcy is saying derogatory statements like dud and buffoon. To be fair, we as lawyers get called a lot worse by our clients. Like often.
That is true.
Yeah. And berating behavior. Also, to be fair, we get berated by our clients. I was talking the other day about a client that was so angry with me, and I was being yelled at by the client and berated right up until we got a signed order from the other side. That was everything that she was asking for. And then it was, can I buy you a beer? Yeah, that's just the job.
Oh, I had a client who would send me the worst letters, like basically to a degree where if I wasn't this person's third lawyer, I would have fired them. But the reason why I was keeping them on is just like somebody has to help this person, and I'm somebody and nobody else will, because this lawyer was or this client was such a giant jerk ass. It was like somebody's got to help them out. So I guess that can be me. And the file sucked. It sucked real bad. But it was just like, okay, we're just going to keep doing this and we're going to do what we can. And they were sending me threats. They were sending me this. They were sending me that. And eventually we won, because I'd been saying, hey, we're likely to win this one. And after that, the guy was like, you are my bestest friend ever.
Yeah.
It was just like, it was like, didn't I tell you that this was going to work out? And it's like, yeah, but I didn't think you were doing a good job. I'm like, okay, but
that's fair.
Yeah, it was just like, okay, but maybe don't threaten me. Like that was not necessary.
Laura's making accusations in the chat. Now, this is true, but there's a caveat. Didn't you tell a client you'd stab him with a fork? Yes, it was a plastic fork. And the client was telling me that when they took the stand after we were done, they were just going to go ahead and lie like the other person did. And I looked at the client. I said, I will stab you with a fork. Yeah, it's not the worst. You know what? I don't take that back at all. I do want to say, Doodlebug, Rob and Runkle, can I get a birthday shout out, please? I'm 53 tomorrow, and EDB isn't in town for me to stalk her to demand she wish me a happy birthday. Doodlebug, happy birthday. Happy 53rd birthday tomorrow. Enjoy the last night of 52, and welcome that 53rd year.
Happy birthday, and I'm sure EDB is wishing you a happy birthday in spirit, notwithstanding the fact that everything interesting happens when EDB is away, including this.
What are you doing? Or the Boone stuff? Or are you going to play something that I wasn't privy to?
No, I was saying the birthday.
Yes, the Boone stuff.
No, the birthday is the interesting thing I was referring to there.
Exactly. I just didn't. My brain was on slow mode. So,
all good.
Court's colloquy. The court says, Bankruptcy, you can get out. Bankruptcy is out. Then sets status conference and gets another attorney. Pointed out the deterioration of the working relationship between defendant and Bankruptcy. Okay. Status conference gets held. Hobson Where are we here? Hobson filed the motion to continue. There we go. So Hobson's the new attorney. Continuance granted because he's got to get caught up in the case. Then he moves to withdrawal. These attorneys do not last long. They have never lasted long. You have an appointment that gets made. What is this? October of 2023 until February 1st. 3 months. 2 months. 3 months. My math.
Fun
Motion
times.
withdrawal. Says bye. Oh no. The court twice advised defendant that defendant may not be provided another court-appointed attorney, and the defendant would have to represent herself if circumstances similar to Hobson's motion withdrawal occur.
Whoops.
Yeah. This is the F around and find out of decisions. So then she gets Cashman. Patricia Cashman. Patricia Cashman has extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. Why is the court giving that caveat? I don't know. April 12th, the status conference gets held.
I can't
Cashman
imagine why.
advised as the depositions that had been set, the hiring of an expert, and the request for a future status date to address the trial date. So she's doing the work. On June 7th, after several months of work, and this lawyer, Ms. Cashman, had put in some substantial time, when did she get appointed? She got appointed. What was this hearing? This hearing was in February. So she gets appointed in February, and she lasts all the way. Oh no. This was the June hearing. So she makes it all the way to June, and she's not the one that files the motion withdrawal. This time it's being brought up on Sarah Boone's request. So she makes it from February to June. February to June. Defendant was present for a hearing and was sworn. Thereafter, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed by Cashman, utilizing a, quote, pretend judge, end quote, to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism, and providing the court with letters dated June 4th and June 7th of 2024, both of which were filed on June 21st of 2024.
As one does.
Oh, God. Footnote 10. The June 7th letter sets forth ad hominem attacks on Cashman's professionalism and, quote, untruthful answers, end quote. See page 8. The June 4th letter sets forth ad hominem attacks on Cashman's professionalism. See page 3. Both the June 7th letter and June 4th letter confirm the defendant disconnecting and or walking out of meetings with Cashman. Oh, that's not good. Cashman advised to her efforts and time spent on the case so far, 20 hours, pretty judicious use of time. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not legally be important. No, you don't say. No way. I am utterly
this doesn't
shocked.
This doesn't sound like a like a crazy self-rep at all.
No, this is you know what? This is my shock face. Defendant then accuses Cashman of lies and half-truths. June 11th, Cashman moved withdrawal under Florida rule regulating the Florida bar. Substantial risk the representation of one or more clients will be materially limited by a lawyer's responsibilities to another client. Basically, she's taking all of my time. I can't defend others. And irreconcilable differences, including but not limited to ethical considerations, have arisen such that counsel can no longer provide representation. When your lawyer is accusing you, or when your client is accusing you of lying and being unethical, you kind of have a problem.
Yep, that's time to go.
At no time has the defendant refused to accept the services of any of her 7 appointed attorneys. Oh, God. Do you know how high this burden is? Never mind. The judge explains it. The counsel clause of the Florida Constitution under Article 1 recognizes the right to counsel as well as self-representation in all criminal proceedings, so it's there for everybody. The forfeiture issue. A defendant in a criminal case can forfeit a right to court-appointed counsel. Yes, you can. Ms. Boone has done it. You done did it. You done did it. I want my highlighter back. Where's my highlighter? It says I have my highlighter. Where am I? Nope. Where's my highlighter? I want the highlighter. No. Annoying. A forfeiture is an extreme measure that flows from the defendant's abuse of or manipulation of the right to counsel and results in the defendant being required to represent himself or herself, even though they have not waived counsel and may still want legal representation. You got to do a lot to get there. Forfeiture is a judicial response that adapts the course of the legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. Step around and find out. As set forth above, defendants, and to give you an idea of how strong this is, the judge in a 16-page order laid 11 pages of foundation. This is not taken up lightly. As set forth above, defendants' recalcitrance to the attorneys who were not conflicted out, Padilla, Bankruptcy, Hobson, and Cashman. Antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, see footnote 9 above. Bankruptcy and Cashman, and personal attacks on Padilla, Bankruptcy, and Cashman. Each of these attorneys were required to withdraw. See, this is the stuff you don't do. Then
Or
the court
do,
cites,
because it's hilarious.
I mean, the court cites the third circuit case, which found that misconduct in relationships with 4 attorneys, including verbal abuse, tearing up correspondence, refusal to cooperate in producing a witness list, hanging up on counsel during telephone conversation, resulted in forfeiture. Well, this sounds kind of similar, at least tracking. It has become apparent to the court that the defendant will not permit herself to be represented by anyone. Wow. That is a sentence. Apparent to the court, defendant will not permit herself. You just can't get out of your own way to be represented by anybody. Additionally, the withdrawal of 8 different attorneys, 7 of which were court appointed, leads to a determination the defendant has forfeited his right to counsel. I think he meant her right to counsel, but probably citing. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. As
Oh,
court
9 Inch
finds-
Nails gal. Good to miss you too. Sort of noticed your absence.
Glad to see you back. Where are you?
Yeah, absolutely.
Missed you, damn human-shaped parrots. Also, 7-year-old finally has ADHD diagnosis. Congratulations on the diagnosis. Hopefully the treatment begins and helps and you have answers. We get start meds in a week. Ozzy, love to you and Ian. And anyone else that shows up. For F-bomb's sake from 4-year-old recently. Imagine that was probably for fuck's sake that your 4-year-old said out loud. And I am laughing at that on the inside very, very loudly. As the court finds the defendant has forfeited the right to court-appointed counsel under Florida law, there is no obligation to conduct a Ferretta hearing or to otherwise warn the defendant of the dangers of proceeding pro se. Already did it. Waiver by conduct. See, guys, it's like the judge and I were communicating behind the scenes. We weren't. Judge knew what we were talking about. The court can find a waiver by conduct to the right to counsel. A waiver by conduct requires the defendant be warned about the consequences of his or her conduct, including the risks of proceeding pro se. Don't keep doing this. You keep doing it, you're going to lose it. And if you lose it, it's not going to be good.
It's not just keep doing it. It's fuck around and you're going to find out.
Yep. And you're not going to like the find out part.
That's the warning.
Yeah. On February 9th, the defendant was twice advised that another court-appointed attorney may not be provided. Well, that's warning. On May 10th, several months later, the defendant was advised about the dangers of self-representation. On February 9th, the defendant was advised about the dangers. So basically just laying out more foundation. As of February 9th of 2024, the instant case had been continued 16 times. As of June 26th, this case has been pending 4 years, 3 months, and 5 days from the date of filing. What the fuck? On this, the judge and I emphatically agree. Actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on the merits, the concept of which was first brought to defendant's attention on May 10th of 2022, more than
And I
2
see some
years ago.
people saying that she needs a free lawyer. Unfortunately, I am
She's
not
amazing.
licensed to practice in the U.S.
You don't
and
want that smoke.
therefore, I just can't take this client on. It's tragic.
Yeah.
Otherwise I'd be first in line.
I'm so sure, so very positive that is exactly how you feel about this.
Also, Tragos is 3K from 400K subs. Awesome.
Oh, wow. Congratulations.
I just hit 275,000.
Congratulations to you. Way to go. That's awesome. And that's a great time to issue a reminder to the chat. Please go subscribe to Ian and subscribe to here if you like it. If you like it. Well, like I said, I don't inundate you guys with notices. Stream like once a week, maybe twice a week, depending on the circumstance. Right now, I'm currently between houses, so the studio is not a studio. It is just a mock little bedroom that is annoying. But I have the little light up, so it's kind of fun. Defendant complains that Bankruptcy and Hobson, 2 court-appointed attorneys, failed to meet and communicate, and when defendant is provided court-appointed counsel who will meet and communicate, Cashman, the ways and means of meeting and communicating are unacceptable to defendant. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel. Cashman shall give the court an order for cost to obtain transcripts of depositions for the 2 witnesses Cashman deposed. So basically, you get the transcripts, all the evidence goes to Sarah Boone. The file goes to Boone. Defendant Sarah Boone has forfeited her right to court-appointed counsel. Alternatively, so the judge knows that this is an appealable issue. Alternatively, defendant Sarah Boone has, through waived by her conduct, her right to court-appointed counsel. The trial management conference shall remain specifically set for September 24th, 2024. Do not pass go. Do not collect $200. We are going to trial. This case shall remain specifically set for trial for the 2-week trial period beginning Monday, October 7th, and will not be continued for any reason except extraordinarily good cause, and such extraordinarily good cause shall not include the retention of counsel by the defendant. Wow. Go off, judge.
Wow.
So that's a thing. Holy crap. So sorry that one didn't make the docket when it was announced, but we are all smarter now for having read that. This is going to be nuts. Absolutely wild. Oh, Court TV, thank you. 2 peas in a pod. That was the all caps that you got hit for, but I was still able to see it. Yeah, 2 peas in a pod. We're just buddies. He's got my tie hanging on the door if you didn't notice that. It's a lucky tie. Has the tie lost yet?
Yes.
Damn it. What's the win-loss record for the tie?
I think 2-1.
I'll take it. That's not bad. Criminal defense, that's not bad.
Yeah, no, it's pretty good.
Yellow pill. Okay, hear me out. During the next charity stream, read the letter with a voice changer.
We could set that up. for the Extra Life charity with a yeah.
And I will tell you, I could only get through reading that if I could not, in my own ear, hear the changed voice. So, thank you, Yellow Pill. Baby Gator, motion for Rob to read the definition of taint.
Which definition?
There's several. Are we talking?
Because there's
like
more than
Black's
one.
Law Dictionary? Because Black's Law Dictionary, we can do that one. I just don't think I don't think that's what you meant. B. Hartling, don't think it'll be another Brooks. She's not a sov sit. She is not a sov sit, but she is trying to advance a defense, namely the battered spouse defense, for which these different attorneys have essentially, we're reading through the lines, advised her there is not a factual foundation to assert this defense. And by doing so, or trying to do so, one, the judge is going to deny it. And two, you risk placing your mental state at issue. Like, you really risk opening the door to your character traits. So do you really want to go down that path?
Yeah, I think I could really strongly see a situation where she starts trying to advocate, like, to advance the battered spouse defense. And then very quickly it transitions into, okay, that's not working. I am sovereign.
No, what my fear is that she is going to advance that defense or try to lay some foundation for it. And she's going to knock the door and boot it right open to a lot of stuff that's going to be remarkably prejudicial to her. So
I'm pretty sure she would say that there is no prejudice to her because she is completely innocent.
It's her truth.
And therefore there's nothing to worry about.
Probably. Christine, would Sarah still get standby counsel? No. Honestly, if you're reading the judge's ruling here, she has forfeited the right to counsel. She has not declined representation and been offered standby. She has, by her own actions, told the court, I waive my right to counsel. Now, the court can still appoint standby counsel, and I believe the judge would likely do that just to preserve the case against appeal. I wouldn't be surprised if you saw the prosecution move for the appointment of standby counsel. If I'm the prosecutor in this case,
I think that they'd have standby counsel just
there.
And I mean, just to, not even just for appeal issues, but also just for standby counsel can often prevent headaches. And I think that you might see standby counsel trying to do their best to limit bullshit.
Yeah.
So,
Baby Gator, how long will it take for Sarah Boone to write a letter to her fans asking to fund a lawyer? See, that was something that she did very stupidly. Well,
does
one
she
of the various
actually
things.
have fans?
She told the judge at the last hearing, she told the judge that she wanted a bond because her fans would fund the bond. Well, here's the thing. If you are telling the court that you have access
right.
to
And she told them
funds,
that she has international fans, so she was saying, oh yeah, not only do I have funds, but I have the possibility to flee the jurisdiction. I remember
that part. Yeah, that part.
Yeah.
Where she made the argument you do not make. Like she did all the things that you can't do. This isn't destiny to be. This isn't even funny. Brooks has time. He can advise her. LOL. No. Terrible.
I mean,
Well,
it is actually at least a little funny.
It might be a little bit. Mama Wolf, I wondered when a judge would put their foot down. I knew it was coming, and I think I predicted, like, as of the last hearing, that this was kind of the last one.
She doesn't
There's
need to
no
worry
way.
about when the judge is going to put his foot down. She needs to worry about when the judge is going to put his foot up,
Up.
specifically up her ass, which seems to be what's happening.
That just happened. Cabot Porter, shouldn't everything lean to the accused's benefit? I'd rather let 100 guilty go free than falsely convict one or something like that. The thing is, you can't stop people. You can't stop people from getting in their own way. You just can't. at some point in time,
somewhat can.
you try very, very hard. You try very hard to say, please don't do the stupid thing. Please don't do the stupid thing. And you say it over and over and over again. You do as much as you can.
Client, tell me more about the stupid thing. That sounds intriguing.
You do it. You say it. You tell them, don't do the stupid thing over and over and over again. You try like hell to put a roadblock between you and the bad decision that client's about to make. That is the job of the attorney, to lay themselves. I mean, we jump on a sword all the time for clients. Like, it's not their fault, it's our fault. You do that. That's the job. But at some point in time, a client can be so persistent in getting in their own way that they shove you aside. In this case, they shove 8 attorneys aside. They're like, nope, I am going to get in my own way. At that point in time, you've done everything you can.
I mean, there is still one thing you can do, which is laugh.
Oh, okay. I thought you were going somewhere else with that, and I didn't know what to do, and I didn't know how to respond. You kind of freaked me out, but I'll take it. Lori Baldwin, if the case does end up being retried with defense request change of venue, this is in regard to Karen Reed. No, I don't think they would. Well, they might, but I don't think there's not really if it gets retried, there might be a basis for it, but we'll see.
Yeah, they might say, listen,
putting the cart in front of the horse.
We've exhausted the jury pool now. There's been so much coverage, and I can see it.
At that point in time, it's the passage of time. So I don't know. It would be a hard case to retry for any side, for the prosecution, for the defense. I mean, it would be. Think about the prosecution's point. Let's look at Lolly's point for a second. If he's trying to retry the Karen Reed case, he was talking. I mean, he gave a full-on defense of Jen McCabe and talking about the witnesses and all the above, and he's got that in mind. He knows that bringing this thing back to trial is only inviting more scrutiny and all of that.
Well, and every witness that gave conflicting testimony, the conflicting testimony that's already there is fair game for cross-examination,
yep,
as well as any further conflicting testimony. So witness testimony only gets worse on further trials. Trooper Paul can't fix his analysis, but what they could do is they could replace Trooper Paul and get an expert that can make an EEG beep.
Trooper Paul. I was about to say you were unfair to Trooper Paul, but then I take that back entirely.
No, I was entirely fair to Trooper Paul.
Yeah.
My policy on Trooper Paul is that he can go and do a letter to himself.
Captain Porter, Ian, this should be your first pro bono case. I think he respectfully declines based on the fact he's not.
Yeah, I just can't. I'm sorry. I wish I could.
Yep. Graham Leonard, a bit late on this, but Massachusetts is one of 7 states where judges aren't elected. We find the idea of judicial elections very strange. So do we in Virginia. So we do not elect judges.
That's good, because we don't in Canada either.
Election.
We don't in Canada either, and we find it very messed up as a notion.
I don't like the idea of judges running. It's difficult. Yeah.
I mean, you see judges promising things like, I will get more convictions. And I'm like, I
don't like that.
Like, shouldn't you get more of whatever cases happen to come your way? Yeah, I don't care for that in the slightest.
Yeah, me either. Pamela Weisenbach, Ian, my husband spares by hot and sour soup for flu.
I agree. I have hot and sour soup, although I also have, what do you call it? I also have wonton soup, which is basically just broth with lumps.
Solid choices. Frog Girl, has she claimed herself a sovereign citizen yet? Not yet. Still to come. K-Rap, that is where she's gotten letters of support from.
Why?
Maverick. What?
Like, how does she think the letters of support help?
They don't.
No, but she certainly seems to think they do.
She thinks a lot of things help.
That's true. If she made good choices, then maybe she wouldn't be where she is. But also, pro tip for the guys: if she says she wants you in a suitcase, don't do it.
Yeah. Like, no. Ever. No. So let's not do that. Agent Maverick, new 5-bot message. Let's get ready to run Cole. It's possible. That's his decision. Shell C, FNF is good entertainment while I have to work late tonight. Hope everyone has a great weekend. Have a good weekend. Shell, hope you're doing great. Sam Ramadan. Whoop. I successfully defended my PhD dissertation in construction engineering 2 days ago. Congratulations, Bassam.
That is
FNF
awesome.
has been a great distraction from all the stress and anxiety in the last couple of years. Thanks, Robin Ian. Congratulations, Dr. Ramadan. Way to go.
I love the person online who said that they, whenever there's a PhD defense, they just, and they're discussing and the person is like stressing out outside. They say that they just walk out and they're like, congratulations, something along the lines of, doctor, could you come back in for a second? And, just like,
That's
I was
solid.
just like,
that's solid. That is such an awesome thing. Like, and to catch him off guard with that too, like, hey doc, you want to come back in or something like that, just to where they're so nervous they wouldn't even catch it. That's so
yeah. And then it's like, wait, what did you say?
Wait, you said something. What did you said the doctor thing? Really? That's cool. That's cool. I wish I could actually see that happen. That'd be really fun to watch. Y'all ain't right. The lawyers withdrew because they repped her boyfriend. Oh, yeah, that's mandatory withdrawal. Jen Edwards and Leonidas the Kitty. Can you raise a glass for Tony P's dad? He passed this week. I can absolutely do that, having lost a father. It sucks.
I'm not drinking booze tonight because not feeling well, but
cheers to you. May you remember all the good memories and may you continue to talk with him as much as you can. He'll always be on your shoulder and just, you'll get through it. Doesn't get easier. It just changes. So cheers to you, Tony P, and your father. May you rest in peace. And just like that, we get to this one. Yellow pill. Comes now my fair and lawful law trial. Don't do it.
that title is a little complicated for a porno, but
See, I knew it was gonna happen. Billy's Momzilla, but did Boone keep her shoes on and did it snow? These are facts we don't know yet. Maybe we'll get through 5 weeks of evidence to establish them.
yeah, I was gonna say we need like multiple weeks to prove that.
Robin, the ADR Pro, don't you mean the batterer spouse defense that she did not know what she was doing because she was using the because she was used to battering George? I see the play on words. I see what you mean.
She is trying to argue that she was the victim as opposed to the aggressor.
Dalton, question. Boone equals bad, but will it be uncivil? Is muted bad? Probably. There's probably going to be at least one or two moments when that's going to happen. Oh my God. Oh my God. Laura M. I don't know if wins the internet or loses the internet. I don't know which one that is for right now. For those of you not looking at the screen, Laura M makes a comment. Comes now. 8 attorneys pull out. Oh God, you guys kill me every fucking time. Ian, I hate you for it, but you know what? It was well done. Well done. Oh my God. Morgan, when everyone else is an asshole, check yourself. Good advice. Chris,
yeah, the other way I've heard that phrased is if you walk around all day smelling shit, check your shoes.
Check your shoes. Other than check your underwear. But either way, Kristen MI6, July 8th is the anniversary of the Wood Daddy Stacks stream. Plan ahead and get your wood stacked as needed.
Get your wood stacked sounds like a Very particular form of euphemism.
Didn't know that. Alice Ann, off topic, but does Ian believe me about the Karen Reed emergency sirens being rigged yet? Notice not a single one during defense case. You're both great. I didn't actually. I thought there was at least one. No,
I don't know. It's
there's
interesting.
one. Canonical Heat reminding everyone, please like, subscribe, and tapping the bell is good luck. It is. It brings you very good fortune. I don't know if that's true or not, but couldn't help to hurt. I mean, couldn't hurt to help. Everyone knows this. You know you want to. Please do that. Hit the like button, hit the subscribe button, and please tap the little bell. Ohio Pom Mom, I love the judge counts days like she does. Like, we're going to stop at 3:30 or 4. I just want to get out of here. We're going to give them the weekend all the time. Gotta love the judge commitment to that. I Rescue Dogs, thanks for Friday Night Fun. Thank you for being here. Liar Bird, not sure how people retain a good defense lawyer from jail. Everyone on TV already has one. Call my lawyer. Should I shortlist ahead of time just in case? It's good to have a name. It's good to have a name.
I know who I would call. I probably know my top 5 who I'd call in order. So
yeah, I've got like 3 that I'd probably call. Yeah, and it would vary based on what the issue was. Like when Brian Steele was getting like detained for the contempt, there's a specific lawyer that I would call, and I know who that lawyer would be, and it would have been humorous. But yeah, a non-mouse. I do believe the judge may be irked. I think that you are right in that assessment. Kristen M96, is Sarah Boone your one trial for the year? I don't know yet. We'll see. Melissa Smith, the relationship is waived by your conduct is my new favorite way to break up.
Oh, that
is so good. Oh, that is so good. Oh, that's awesome.
That
me, it's
is
you.
distressingly good.
It's not me, it's you. No, this relationship is waived by your conduct. That is
I love
phenomenal.
that so much.
Oh my God. I 1000% agree. That is awesome. Melissa, thank you for the contribution. Diana Dodson, thanks for becoming a member or being a member for 20 months. Baby Gator, Sarah Boone has the taint definition in her letter. Oh, I'm not going back to that. I'll read that later.
Which taint definition, though?
I don't know.
Because that could go in different directions.
Oh. I would hope that her letter would not be referring to. Never mind. XCDA, by my account, you owe us 3 swoops. Are they packed up for the move? No, the swoops are not packed up. I will get to them. I promise you.
I can swoop.
You can swoop. You want to swoop? You can swoop.
What's a good swoop?
You scared me for a second there. You scared me for a second. The last time that you created a swoop, it was inappropriate.
I don't think I have the ability to upload swoops.
Well, you did it last time. You shared screen and it was there.
Oh, that's true.
Corwin, Ian, are you doing fireworks on Monday?
I am not.
There you go.
Not this time around.
Angel Baby 4210. She has an arrest record for DV. She will open that door if she goes battered wife syndrome. And that's probably what the defense that is absolutely put at issue. 1000%.
And I can guarantee you that every lawyer she's talked to about this has been like,
yep,
you are about to do the dumbest thing on the planet. Are you sure you want to do the dumb thing? Because the answer is no, you do not want to do the dumb thing. And she goes like, no, I want to do the dumb thing. And and then the solicitor-client relationship breaks down because it's like, the lawyer is just like, oh, so you want me to go in and just like completely tank your case for you? Cool. That sounds like fun. And I'm sure you won't ever complain about me to the Law Society afterwards.
Not at all. No chance. After you get convicted and you have to stand there and have the prosecutor go through that domestic violence charge, No way are you going to possibly blame me for the consequence of your own decision. There's no way.
Yeah. Exactly.
Yeah, that's a bad move. K-Rab. Brooks, for all his soft sit, BS was brighter than Sarah. I don't know. I'm not going to assess intelligence of those two individuals. He learned from what the DA was doing. Sarah just copied entire sections from law books based on buzzwords. She didn't understand enough to limit to what was applicable.
That just kind of seems like we're comparing the intelligence of like a lemon and a pear.
Or a stick and a rock. I don't know.
It's like, which is smarter, this brick or this shoe?
Lucifer, this is a solid troll remark. How many pieces of plastic fork were found, Rob? Hello, 19, probably. I have no clue. Brandy Rose, I'm sorry, what? Almost never catch FNF live. Thank you both for all you do. Runkle, your Karen Reed recaps have been amazing. I agree. You both and EDB helped me recognize and receive my ADHD diagnosis. You helped me feel seen. Randy, that helps me feel amazing and wonderful, and I'm so glad that you sought out that for yourself.
Absolutely.
Tony P, thanks, Jen Edwards and Leonidas the Kitty. Gone far too soon at the age of 63. Fuck cancer. Tony P, fuck cancer, and the horse she rode in on. Absolutely could not agree more emphatically. Cancer sucks. Yeah. I'm sorry for your loss, sir. I love the avatar, though. I really do. The sword is awesome. Peggy Reardon, I had a lawyer who told me he did not return client calls as they have nothing useful to offer. He didn't cross-examine the offender. Mistake. I lost the case. Yeah, that's not a good one.
Yeah, sorry. Sometimes the client has the entire case to offer.
Yeah, that's it's not good. If Brooks is busy, maybe Janet Braun can help. Nope. That's a very fast way to get a conviction. Just terrible.
Yeah, I would not Janet this one up.
Dogs Discussions. I can give the shout out to the YouTube. Dogs Discussions YouTube. You can check that out. Please do. I imagine there's discussions about dogs. I haven't looked at it myself. But please, I welcome everybody. If you guys create a YouTube and you're out there like talking on the platform, you're doing it responsibly, we'll gladly try to shout out everyone I can. I can't see all of it all the time, but I do try to point it out when I'm aware of it. Jolly Rogers, please remember to support Pixie on the anniversary of Corey's passing. She said she would live stream. Jolly Rogers, thank you for the reminder. Please do so. The Crap Goth is her YouTube. Okay. I owe a swoop, and I owe some coverage of Young Thug. So double swoop.
And I really want to hang around for Young Thug, but unfortunately I am rocking the flu. I am going to crash. I may
eat food first.
I will probably eat some food.
Yeah.
Depending on how sleep goes, I may come back, but I'm going to try sleep.
Give it a shot, buddy.
All right. Good night, everyone. Sorry I'm tapping out early and being kind of but I got to
take care of yourself first, bud.
All right. Have a good night, and thanks for letting me pop in here. So
thanks for being here always.
Good night.
See ya. You got to remove yourself. Yeah, there you go. You know how to do it. You know the buttons. And why not? Another one. For Ian's speedy recovery. So, okay. Next topic we've got to discuss is the Young Thug RICO trial. My God. If there was a trial that would never end, this is the trial that never ends. Yes, it goes on and on, my friends. The judge just started ruling and that couldn't stop himself. And he'll keep on ruling. So, catching people up to speed on the Young Thug RICO trial. Judge Glanville is in a bit of a pickle. And by pickle, I mean that he actually conducted an ex parte hearing with a witness after they were sworn. That resulted in Brian Steele, the lead counsel for Young Thug, making a motion for mistrial based on the ex parte that then resulted in the judge accusing Steele of getting information from Chambers. There's a lot of back and forth, pretty messy. Judge Glanville held Steele in contempt. That got appealed. Supreme Court said, we're going to keep him out of jail while we're pending the appeal. And you basically have everyone trying to go and find out what the hell happened in the ex parte hearing. What happened during this ex parte hearing? Ex parte hearing being a hearing outside the presence of one or both parties. So what we had back and forth in this case was essentially a summary of what we believe transpired during that meeting, given by presumably either the witness themselves or the attorney that was representing the witness. And it ain't good, because what was discussed was the witness's assertion of their Fifth Amendment privilege, then the statement that if they did that, having the judge find that there was no Fifth Amendment privilege, that the judge would hold them in civil contempt and leave them in contempt, incarcerated until such time as they complied, which would be in excess of 2 years because there were 26 defendants. And then the defendant said, fine, or witness said, fine, I'll testify, but I'll lie. And then the prosecution says, well, then we'll revoke immunity and we'll prosecute you. And a whole lot of fuckery, just outright. I've been rather vocal about this because, well, one, all of the no on the ex parte communication, not allowed. It's not a thing. No, you're not allowed to do it, especially when a witness is sworn. And two, how are you now trying to hold these attorneys in contempt when you didn't issue an order that would direct them to do something one way or the other? So now we're having a big debate over the transcripts and whether the transcripts from the ex parte hearing are going to be disclosed, because, they're kind of important. There's a court reporter back there. We have the right to know what the hell happened. And the judge is going, well, maybe we're not going to give all of them, maybe some. I don't know. We'll decide. But that's the substance of this hearing, or this portion of the hearing that took place. So that's a preview of why we're here, what we're discussing, and what's going on in this particular one. I've got closed captions turned on, so you'll be able to see those. I don't know. What do we think? What is Glanville going to do? Is Judge Glanville going to say during the course of this hearing that, you know what, counsel, you are right. There is no privilege that would allow me to redact or withhold any of this from your client, and they have a right to see what took place in that chambers meeting? Is that what Judge Glanville is going to do? I don't know. I mean, I do know because I watched this and it made me mad. So maybe that's a preview. I don't know. Let's watch.
Of July. As I mentioned earlier, we'll bring your clients over. They'll be here. I'd ask counsel to meet.
Wait, back up.
Anything else we need to take up at this point in time?
Nothing from the station.
Anything from the defendants?
No, sir.
Okay. Monday, the 1st of July.
That's this Monday. That is this coming Monday. That is the day that's like 2 days, 3 days from now. That's when this is all going to happen. Oh, yeah. Here we go.
I mentioned earlier, we'll bring your clients over. They'll be here. I'd ask counsel to meet 8F jury room for Monday at 9 o'clock. All right? For the in-camera review.
And on that, Your Honor, again, and I know I said it, so I'm assuming that it's reserved, but Mr. Williams would like to be present.
Yeah, you told me that already. Do you have any additional case law other than the United States 6th and Georgia 6th Amendments?
Georgia is Article 1, Section 1, Paragraph 12. I believe Mr. Williams, I need him there to review. I assume we're getting a transcript. I don't know if that's.
I'll cover that on Monday. Mr. Williams will be brought over, but the part that you all are here are just for in camera. That's attorneys because of the privilege potential that is that may be discussed no, I said not discussed, identified.
So what the hell is happening? What the hell is happening? What are we doing right now? One, I'm sorry for the screeching. That's law and crime. That's not me. So that's their mics being a little bit peaky and just giving god awful feedback. But what's going on? Basically, the judge is saying, look, we're going to go review the transcripts and we're going to do this in this fashion. So the attorneys are all going to meet in this room and we'll go through the transcripts. And what Mr. Steele is saying is, look, my client has a right to confront the evidence against him. Like, he has an absolute right, a Sixth Amendment right to basically say, I can be present for every meaningful proceeding of my case. And the judge is basically saying, do you have anything other than, the Constitution? One, that's a bold take. But what the judge says there at the very end is the most unique part. Privilege. Rewind a little bit. Let's see. Let's hear the privilege thing, because that's where I want to kind of focus.
Be just for in camera. That's attorneys, because of the privilege potential that is that may be discussed. Or no, I said not discussed. Identified, and you all as lawyers.
Stop spinning. Don't do this to me. Don't. Do not. Do not. Not when Judge Glanville is saying something that I think is stupid. Please don't do this.
Are, of course, subject to the rules of professional responsibility. Third parties or your clients and other people are not.
Okay, well, I oppose that objection.
And sir, if I have anything else, I will certainly reconsider that. But at this point in time, for that particular purpose, until we get through the in-camera review, I will, when the transcript is reviewed, the court's intention is to review everything for for Brady and/or impeachment. And then I will flag all those, and then anything else that you all wished for me to consider, I will then, you can.
Stop. I need this to work. I'm going to reduce the quality.
I will then, you can mark, and then we can have a discussion about that.
Okay, and I'd like it done in open court as well, in Mr. Williams' presence, of course, and in court.
Okay, I don't think he can do, until I identify it, Mr. Steele, and make rulings on it, he doesn't have the right to be present. You're the person that's present for him at that point in time, because it covers privilege.
What privilege? What privilege? He keeps saying this word. Wait, where's my sound? Where's the sound? I think I have it.
You keep using the word. I don't think it means what you think it means.
Yeah. You keep saying this word, but do you know what the word means?
It's just like if you had defects records, okay? You and Mr. Williams could not come to my chambers and review those records. You could, but he can't. Now, once I've ruled upon those, of course, I will copy whatever periods of the transcript, portions of the transcript that I believe are.
He just made an additional very stupid statement. I'm sorry. I know I'm going to get like upset with this judge. I can't anymore. I cannot anymore. I'm done with the whole giving this judge any. This is ridiculous. So what he just said is, it's just like when you are viewing statements that the defendant or a defendant gives in the presence of their counsel. Well, no, it's not. That's not the case. That is not what we're talking about. We're talking about a meeting that took place with the prosecutors present, with your sheriff deputies, with you present, with the witness and his attorney and the court reporter. You involving or having any other people other than just, I'll explain a little bit more in a second, but
appropriate, and I will make other rulings in regards to sealing that particular portions which are not for any other review. And then you can take that to Mr. Williams and all of you can talk about that.
I understand. I just,
I know you, I know you've made an objection as to that, as to your client's.
Yep. And you know who's right? Again,
Presence, but for the privilege or for the in-camera review, he doesn't have the right to be there. I respectfully disagree, but
I understand that we are in disagreement, but I'd also like to then
oh,
open courtroom. I believe that it should be done in open court as well, and that's under Article 1 and
okay.
the first in the.
I understand that. I agree with you about the open court. I understand about the open courtroom. I agree with you about the respective constitutional provisions. I disagree with you about the in-camera. That doesn't apply to an open courtroom. The in-camera review of these records. So we'll just, like I said, if you got some case law, you got something for me to consider, I'll certainly look at it. But at this point, that's what my ruling will be in terms of your client's collectively presence. However, like I said, once the court makes those determinations as to which things are to be released to you, and I copy those transcripts for you, those portions or the transcript for you, then your clients will be here and you may take those portions and discuss those with your clients. Okay.
Cool.
And then we will have the rest of whatever we have in open court. Okay.
Any idea what those rulings might be, Judge? No. Anyone want to speculate whether and to what extent the judge says that certain parts of the transcript that's being reviewed are sealed and not to be seen by the public or by the defendant? Anyone else want to venture a guess? I generally wouldn't put the cart in front of the horse, but this judge has given me enough. Pretty much. Yeah, I think I have an idea of what he's going to say with regard to the transcripts.
Understand the ruling.
Okay. All right. Like I said, if you have some case law you want me to look at something, I'll certainly look at it. Because I
believe that under United States and Georgia Constitution and Presley, it's a voir dire issue, but I believe this should all be done in open court, not in a closed courtroom or closed chambers, jury room.
You are correct about anything else, but when you're dealing with a matter of privilege and or
there it is.
Depending upon the type of records you're reviewing, not everybody gets to see those. And that's where we disagree. That's not an open proceeding. That's a closed proceeding to decide whether or not what's going to be released. Again, I'm going to release to you what the court believes falls within the acceptable range categories of release. It may be the entire transcript. It might be portions of that transcript, but I'm going to listen to you.
You know what? We're going to do a poll. Yeah, we're going to do a poll. Because when we get to because this is the thing. This judge has, this is his ruling. This is going to happen in this fashion. It's not subject to review. This is going to happen this way. And Steele's just making his record. But let's go ahead and we're going to put a poll up for the chat. We'll make it funny. What, if any, portions of the ex parte transcript will be made public? Let's see. Full proceedings. / all. Partial. Let's go ahead and say 25% redacted. Let's see. Partial, and we're going to go ahead and say 50%. Well, you know what? We're going to go ahead and say 75. Let's go ahead and we're going to make it laughable. 86% redacted or none. Fully redacted. You guys vote. Polls live. I hate this case.
Your argument about that you don't get an open courtroom for, because I have to make a determination of whether or not first you get it, and then whether or not what basis you get it for. Then once I release that, I make a ruling, which can certainly be reviewed at some point in time. Then I'm going to seal the rest of the record. I'm going to seal that particular ex parte because it will have some issues of attorney-client privilege. So that's why, or else I give you the entire transcript. It would be fine for me, but I think that that's the issue.
If an attorney-client privilege conversation was captured by the court reporter on a transcript with the court present, it can't be attorney-client privilege.
Well, that's for another body to resolve, not me. And
Really? Because pretty sure you're making a ruling that's privileged. Like, I'm pretty sure you just said, how many times he says that's for another body, that's for a higher court, that's for somebody else to decide? How many times he says that throughout the course of any of these proceedings? And then when he says it within the next, like, basically sentence of saying it, says, but I'm not going to give you a certificate for immediate review. Like, I'm not going to let them decide that now. Ingrid Steen kind of, it's pretty much it. I don't give a shit. That's what he's saying. I don't give a shit. You can't do anything about it. I don't give a shit.
you'll have to first decide whether or not those conversations were had. So once you take a look at the transcript, then we can have the conversation again, because that will affect whether I seal it or not.
That's fine. I'm just want to continuing. I voiced it, so I think it's preserved. But
I think you've said it now 3 times. I think you've gotten your point across. But again, I'm going to tell you again, if you've got a case which says your clients can be present, I'll be more than happy to listen to you. I really will.
Well, my case is every case, but Penny, P-E-N-N-I-E versus State, Sammons, S-A-M-M-O-N-S.
All right, Steele, go off. My case is every case. It's all of them.
Versus State. Ward, W-A-D-E versus State, 1852. But the bottom line is, and they all say the same thing, at any critical stage of the proceedings, the criminally accused has a right to be present. I'm raising under federal as well as state constitution. I'm also raising an open courtroom, not a closed courtroom, under the right to public trial.
I understand that, sir, and I'll take a look at the cases you've cited, and that is part of what the court has to rule upon, whether or not it was in fact, or whether or not somebody else will rule upon, not me, I should say, whether or not it's a critical stage. But let me get through the review of the in-camera review first, and then we can have some other conversations. Okay?
No, I ain't saying I work. I just object. You're overruling it. I'm just
okay. All right.
Thank you.
State, you'll be able to as well join for those of you that were in there as well. I believe Ms. Hilton and Ms. Love for that same review. Okay. Thank you. All right. Okay. All right, folks. I'll see you on Monday. All right. Enjoy your.
Yes, Judge Glanville, you will. You will see us on Monday. I will most assuredly be watching that at some point in time, because, well, that's if we get to see it. The number of times the judge seals stuff and says, sorry, no, can't be here. I'm not going to let you do it. It's pretty asinine. It's pretty ridiculous. As in ridiculous to the point that I don't know that. I mean, I just don't know that I've seen anything that's awful, terrible. So you guys remember that there was a writ of mandamus that was filed in the Supreme Court of the state of Georgia. That writ of mandamus was essentially directing the judge to recuse themselves. Well, asking that the court direct the judge to recuse themselves. Give me 1 second, we pull it up and I'll share it with you guys so we can take a look at it. Do the things. Find the motion. Not the emotion, but the motion. We can find emotion too. Let's see, share the screen. Promise to be quick because we have other topics to get to. One more topic to get to the evening, and I'm not going to go for 4 hours. Diamante Kendrick versus Chief Judge Ural Glanville. This is in the Supreme Court, the state of Georgia. This was their emergency petition for writ of mandamus and stay of proceedings. We read this last week, essentially walking through some of what was being alleged and the fact that this was being filed at the higher court. Now, I had never really thought in my life I would be, intently following someone on Twitter in connection with this case, much less an account that's just Thugger Daily. But Thugger Daily, phenomenal coverage. Why am I on the blank screen? Don't be the blank screen. Here, I want to share this. No, don't share that. Share this. Thugger Daily has been essentially posting damn near everything in this case. Phenomenal coverage of what's been going on to the point where Kathy Russin from Law and Crime is also following and reposting. So this was the response by the Georgia Supreme Court. Georgia Supreme Court came out and said, let's go ahead and make this one a little bit bigger. Georgia Supreme Court. The Honorable Supreme Court met pursuant to adjournment. The following order was passed. Petitioner Diamante Kendrick, who is facing trial on murder and other charges in Fulton, filed directly in this court an emergency motion seeking original relief in the form of mandamus against Chief Judge Ural Glanville and a stay of proceedings. Kendrick filed in the Superior Court a motion to recuse Chief Judge Glanville after he became aware of an alleged ex parte meeting on June 12, 2024 between the judge, assistant district attorneys, a state's witness, and the witness's attorney. This part, a little hint, because you see a footnote. Chief Judge Glanville did not refer Kendrick's motion to recuse to another judge. See Uniform Superior Court Rule 25.3, and instead decided the motion himself and denied it. Okay. Here, before seeking original mandamus relief from this court, Kendrick is required to show that he first sought and was denied access to proper channels for seeking relief in the Superior Court. And Kendrick has not made such a showing, as he admits that he has not filed a standalone mandamus petition. You see, when the Supreme Court is telling you, like, it's not like that you just didn't do the thing, but when the Supreme Court is coming back and saying, this is the thing you have to do, a standalone mandamus petition against Glanville in Superior Court. Although Kendrick expresses concern that filing a mandamus petition in Superior Court would be futile because the petition would be assigned to Chief Judge Glanville, that is not so. As explained in Brown, if Kendrick were to file a mandamus petition in Superior Court naming Judge Glanville as the respondent, Chief Judge Glanville would be disqualified from presiding over the matter. A different judge would consider Kendrick's petition, and either party may appeal the final decision. Oh, sometimes the losses can taste so sweet. Because what did the Supreme Court just do? They're not supposed to issue advisory opinions, but they basically just highlighted in a directive of what the chief judge must do. And cited to a case, as explained in Brown, if Kendrick were to file, again, the court does not rule on hypotheticals. If he were to file a mandamus petition in Superior Court naming Chief Judge Glanville as the respondent, Chief Judge Glanville would be disqualified from presiding over the matter. That's a fucking advisory opinion. It's a whole ass. That's not supposed to happen, and it's only happening because it's like, we're not gonna do this. A different judge would consider Kendrick's petition, and either party may appeal. So they're also literally saying, when it gets denied, it can be appealed. Like, this isn't one of those things that you have to wait. Accordingly, Kendrick's emergency petition for writ of mandamus and stay of proceedings is dismissed. But is it, though? Because it doesn't feel like it's dismissed. It just feels like it shall be revisited. And the funny thing that was highlighted was that lovely little footnote. USCR 25.3, this is footnote 1, when a trial judge is presented with a motion to recuse or disqualify accompanied by an affidavit, the judge shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness of the motion and the legal sufficiency of the affidavit, which he's done on the record several times, and make a determination, assuming any of the facts alleged in the affidavit to be true, whether recusal will be warranted. Now, here's the little part. Emphasis added is when the court goes ahead and like highlight something or underline something that basically says, hey, take a look at this because I'm emphasizing this particular part of the rule. The Supreme Court is emphasizing this little particular part of the rule. And they're saying if it is found that the motion is timely, which Glanville has said, the affidavit is sufficient. He has said it's been sufficient. And the recusal will be authorized if some or all of the facts set forth in the affidavit are true. Another judge shall be assigned to hear the motion to recuse. See, this is the Georgia Supreme Court kind of tipping its hand a little bit and saying, hey, what the fuck? Maybe you do it the right way. So that brings us to the proper filing. Proper filing was this one. Emergency petition for writ of mandamus filed in the Superior Court for Fulton County. Well, look at that. And then the very first quoted language is as follows. We won't read Ian's favorite phrase, but Diamante Kendrick brings this emergency petition for writ of mandamus showing as follows. Quote, even if a judge did not intend to favor one party over another, engaging in ex parte communications is inappropriate and unjudicial. Engaging in or allowing ex parte communications presents to the public an image of a judge who covertly interacts with a party in order to unfairly advance that party's interests and jeopardizes the appearance of the independence, integrity, and impartiality of the judiciary. And what's even more impactful is that is directly cited from this judicial inquiry that resulted in Judge Christina Peterson being removed from the bench. And that opinion was issued June 25th of 2024. Judge Glanville, kindly be notified that this is the find out part of your fuck around. And then brilliantly, the attorney goes and says the emergency petition is brought under guidance from the Supreme Court of Georgia following rejection of a similar petition by that court. Now, I love that it says under guidance because the court did literally guide them. The Supreme Court never reaches out and says, here, take my hand, take my hand, take my hand. Here, litigant, I got you. This is how we do it. Never. They did here. As explained by the court in anticipation of the present petition, Chief Judge Glanville would be disqualified. They're literally quoting the letter. Chief Judge Glanville would be disqualified from presiding over the matter. A different judge would consider Kendrick's petition, and either party may appeal that final decision. Oh, yeah. This is going to be fantastic. And by fantastic, I mean a disaster. What the fuck is happening in Fulton County, Georgia? So for those of you curious as to what Judge Glanville would do upon, receiving that lovely little petition for writ of mandamus that was filed, and whether or not the instruction from the Georgia Supreme Court would have any impact whatsoever on, how he decided whether he should or should not offload that. It has been assigned. The petition for writ of mandamus is going to be heard by Judge Belinda Edwards. So would you look at that? Assigned to a different judge. Now, why did we have to jump through 5, 6, 7, 17 million hurdles to get to the proper disposition? I don't know. It's a fucking joke. Think about all the time that was taken by the attorneys to just enforce something that was so simple, on its face, within the rule. It was re-articulated over and over and over again. The judge just said, I just disagree with you, counsel. What's funny is the whole hearing on the issue of the privilege, which actually, let's go check that poll. Checking the poll. What's the status of the poll? What, if any, portions of the ex parte transcript will be made public with 993 of you voting? That number's a little bit low. I don't think a lot of you saw it. Vote in the poll. Just go you heard me talk about it. How much of these transcripts are we going to get? What are we actually going to see took place in that ex parte meeting? Why does it matter? How is any of this okay? Shouldn't be. So give you a couple more seconds to vote in that, and I'll pull up some questions. Tina K.S. Law Nerd. But was it snowing during the closed courtroom jury room? Thanks, Robin Chat, for entertaining me every Friday night. I don't think it was snowing, not in Fulton County. Not last week, 2 weeks ago. But I don't know. We haven't heard evidence on it. We might need 5 weeks. Michigan Farm Boy, is the judge trying to say that the privilege is the witnesses because his lawyer was there? Seems to ignore the defendant's rights. This is a good point, Michigan. Thank you. Let me actually clarify this. I made the comment earlier. There are certain very, very limited circumstances where a individual represented by counsel can be compelled in a separate ex parte proceeding that's being transcribed to offer information as to the communications that they contend to be privileged for the purpose of assessing that privilege. So let me give you an example. If, for example, I am saying to the judge, you cannot get this because this communication that I am giving to you right now is covered by Fifth Amendment privilege, right? I have the right to not incriminate myself. The judge says, well, you know what? I'm going to take you at your word. Here's what I'm going to do. I'm going to go back into chambers with you and your attorney. And you are going to tell me what it is that you believe is covered by privilege. We saw this in the Fonnie Willis, the case about whether she gets removed or not. You're going to tell me what you consider to be privileged. And I'm going to weigh that consideration or that claim, and I'm going to basically say whether it is or is not privileged. And to the extent that I determine that that is privileged, here's what's going to happen. That gets sealed, and nobody else gets to see it. Not the prosecutors, not the defense, not anybody. It's privileged. I have ruled that that is privileged and protected. But let's say that I find that it's not privileged. And if I find that it's not privileged, that gets disclosed to the prosecution and the defense. So that would be one way, and I think the only way I've thought of that this could be any claim to privilege, whether it's attorney-client privilege or Fifth Amendment privilege. Here's where that privilege completely disappears, as in like no longer exists. Let's say the same set of facts plays out, right? And instead, this time we're trying to get privileged communication between an attorney and client. And the judge says, witness, you have stated that these things that you don't want to testify to are privileged as attorney-client communications or Fifth Amendment. So here's what we're going to do. We're going to go back into chambers. You know what? Prosecution, you come too. or literally anybody, Joe Schmo from the street, Joe Schmo from off the street. The second that you bring a third party into that discussion and the judge says, let me hear it, tell me what you believe is privileged. And the second that witness says a single thing, privilege is gone. It no longer exists. A third party is present. And at that point in time, I think the judge actually violated at least one ethical rule I can think of. And that actually tells you why these ex parte communications should not take place, except in the most significant circumstances, like the only one that I gave you. Because what happened here was you had a judge with a witness who was already sworn and giving testimony, or not giving testimony, but there was already sworn, which means the defendant has an absolute right to confront the witnesses testifying against him. And with third parties present, other people, the prosecution, a party to the case present, without the defendant present, has a whole ass conversation. And now is saying the defense doesn't get it. That is not how that works. And illustrates exactly why ex parte hearings and proceedings are completely impermissible. Mama Betts, legalese judge speak for go F yourself. I had that. Would you do the white shirt walk from Robin Shermantine? Been close. Like, I've been threatened with contempt several times. Haven't been held in contempt, but yeah, I've usually, when threatened with it, I stand up. And when the judge sees you stand up, most times the judge kind of says, all right, they're willing to put this on the line. Maybe I should think about it. So, SK, oh my God, is he trying to restrict what the lawyers can know about the meeting? He was. And then he said, no, the lawyers can know, but the defense can't. And it's also the lawyers can know, the defense can't. And by the way, the lawyers can know, but I'm also going to issue a gag order and seal it so no one else can know either. That's a problem. 20th Century Fox, is Glanville buzz or am I just projecting? Oh no. Kate, maybe. How does it work to sequester a jury? You send the bailiffs to a hotel and you give them restrictions on all the stuff. You clear a floor of the hotel. I mean, it's not pretty, but it happens in certain cases. Not in this case, or in the Karen Reed case, hasn't been sequestered. The jury's free to go home. Feral Dragon, love you, Rob. Your passion and compassion are amazing. Thank you. By the way, the only thing Judge Glanville won't redact is the word like the and. Yep, we're just going to see a whole lot of conjecture or conjunctives. Gwendolyn SS Copeland said his lawyer was fired before the meeting, which again, no more privilege. It's gone. If the lawyer's fired, it's fired. Book Dragon KSC, wouldn't having the prosecution in the room during Fifth Amendment privilege be unconstitutional? Whole lot of not okay things taking place. Like a lot. All the things. Narcissistic, not YouTube yet, but Twitch. I started streaming cozy games and Lego with a MD and mental health focus. Just hit 100 followers yesterday. Congratulations, Narcissistic. Please check that out. Nicole has ADHD. 18 months. Wow. Did you get the PO box this week? I didn't get the PO box this week. I have a lot to get done before the holiday weekend. And this is a reminder, the holiday next week is the 4th on Thursday. And therefore on the 5th, I will not be doing FNF. So there'll be no FNF next week. I will resume the following week, but no FNF next week. Mark Say from Lolly's Boredom. Feel better, Uncle Runkle. Pass that message along. Harmony DeRoche. Happy birthday to my brother Nathan in heaven. Happy heavenly birthday, Nathan. Happy heavenly birthday indeed. Happy Canada Day to my fellow Canadians, says Linda M. Wolf Kiara, Wolf Kiara says, how many conflicts can this judge get? A lot. Celine, padding out the stream length because chaos. Don't pad out the stream length. You know what it is. B. Hartling, every case Glanville has run needs to be reviewed. I don't know if that's the case, but at least this one needs to be reviewed. Beach, please. Thank you both for your coverage and the neurospicy awareness. It's helped us connect better with our 15-year-old ASD kiddo. I've made the comment in the past. Those comments are my favorite comments to ever read, ever. So let me swoop to the very last topic of the evening, and then we have to catch up. I was speaking during that swoop, so I'll do it again. Very last topic of the evening. I don't know if you guys know who Deion Sanders is. Who is Deion Sanders? Prime time Deion Sanders. Yes, it's sports ball, but the guy's pretty just all over the place, so you probably know who he is, generally speaking. You might actually know that he is currently the coach of the Colorado University Buffaloes football program. Made a big, I'm not going to say mess, but just a whole lot going on, right? So he brings in a bunch of players. NIL is on the table, name, image, and likeness, money is on the table. A lot of stuff is here in this new era of football that just didn't exist. And two of the players that play on Deion Sanders' team are his sons, Shilo and Shedeur. Now, Shedeur Sanders is the quarterback. Shilo is a safety, a defensive player, safety or corner, doesn't really matter. Not for these purposes. So name, image, and likeness has been a big issue that's been circling a lot of discussions. These college players getting a shitload of money via contracts for the use of their name, image, and likeness. And when you have the name like Sanders as your last name, you're no different. You definitely get some treatment. Make sure if I can make this thing go away. Go away, stupid ad thingy. How do I make you not there? Close that. Go away, go away, go away. Share the screen. So here's what we have. Shilo Sanders, flashy habits. This is a big factor in his bankruptcy case. Well, why is he in bankruptcy? Why is a college kid in bankruptcy? What is happening that led to that? So the safety, I was wrong, safety, had shoulder surgery, but he's also got some other stuff going on this summer. Because it turns out that when he was in high school in 2015, there was an assault charge or an assault case against him. And that case ended up going to final judgment. And that judgment resulted in an $11.8 million judgment against this young man, Shilo Sanders. What did he do in the face of the judgment? And actually, let's pull the judgment up at this point because we can. Documents. Promise this one won't be too long because it's just, this is highlighting a lot of stuff that's, well, going to be some curious stuff to cover or see what's going on. You guys remember the Tom Girardi stuff? It's kind of similar. Let's see if we can't get this judgment pulled up. Here we go. State judgment. March 28th of 2022, the above case number. Parties presented testimony evidence to the court. The defendant, Shilo Sanders, failed to appear. After listening to testimony and considering the evidence, the court is of the opinion the judgment should be entered against Shilo Sanders and in favor of the plaintiff, John Darjean, and intervener Utica Mutual Insurance Company. This is for a workman's comp claim. Court findings of fact and conclusions of law are hereby adopted, incorporated, as set forth fully here below. So as a result, on September 17th, assault, John Darjean sustained physical and mental pain, anguish in the past of $1 million. Reasonable probability that will sustain physical pain and anguish in the future, $1 million. Then we've got loss of earning capacity, $375,000. And reasonable probability sustained loss in earning capacity in the future, $2 million as a result of the assault. Sustained disfigurement in the past, 700,000. Probability of sustained disfigurement in the future, 700,000. Physical impairment, 1 million. Physical impairment in the future, 3 million. Incurred medical care expenses in the past of 115,000. 115,000 medical expenses from the assault. Sustained medical care expenses in the future of 2 million. That Shilo Sanders, Dion's son, owed a legal duty to act with reasonable and ordinary care as to not physically injure others, including Darjan. He did, in fact, I'm probably pronouncing that terribly, but he did, in fact, cause that harm and injuries to him by assaulting him. On the date in question, Shilo Sanders owed a legal duty to John not to assault and cause physical injury. However, he breached that duty. The court finds that Shilo's actions were the proximate cause of the injuries and damages, finds that the actions were a substantial factor in bringing about the physical and mental injuries sustained, which injuries would not have occurred, finds the injuries and damages were foreseeable as a result of the assault. Okay. Then there's workman's comp claim, benefits paid out in the amount of 115,000. They also indemnified certain costs, 98K. So this overall judgment is in the amount of $11 million. So 11.89 million. So closer to 11.9 million. But what are we going to go and argue about? You know, what's a few million? So he, Shilo, name, image, and likeness stuff, has ostensibly some money. He's got something. So he filed bankruptcy, and in the bankruptcy filing, he discloses, Chapter 7, so liquidation case, discloses a claim of $477,000 in assets, including $300K in a Robinhood account, $8K in a Wells Fargo account, nothing, zero, declared from his name, image, and likeness projects. Nada. Top line item was for Mercedes GLE AMG, nice car, valued at $75K. Declared value of the assets since been readjusted to $320 without any of the NIL deals reported. Interesting. So why is a judge curious, or why is anyone curious of this? Contrary to his schedules, his bankruptcy filing, he's admitted to acquiring vast amounts of high-end and expensive clothing, according to court documents. For example, on his YouTube channel, oh my gosh, really? YouTube. Posted on May 4th, 2023, he states, all right, we have at the Louis Vuitton store, I'm trying to spend at least $50,000 today. The schedules admit all of the Louis Vuitton wallets, bags, luggage, clothing, or shoes displayed on his Instagram, TikTok, and YouTube accounts. You see, that's a bit of a problem. Schedules make no mention of any number of partnerships, deals, and or contracts with any agents, managers, including but not limited to SMAC Entertainment, Well Off Media, Colorado University. First of all, Well Off Media, really? A little bit pretentious. Tabitha Plummer, George Moskowitz, Constance Schwartz, or any other campaign agent or manager. At the meeting of creditors, which is the meeting takes place where the trustee appointed the case gets to ask you questions and say, did you list all of your assets and debts? Are there any assets that I can liquidate to pay some of these claims? At the meeting, Shilo claimed to possess little to no knowledge of the formation or workings of Big 21 LLC and SS 21 LLC. Those are the LLCs that have the contracts for name, image, and likeness. Except that Shilo is the sole owner of each entity, and the entities are purported vehicles for contracting the paid promotional appearances and or name, image, and likeness transactions of Shilo. So he's the only one that owns the company and says, I don't know what's going on with the company. The company just receives money, which you're starting to see like some shady shit. This is kind of shady. Fails to address and schedules the deals, contracts, and payments made to him and or his companies for any obvious paid engagements. We know you are getting paid. We know the name, image, and likeness deals are there. We are not idiots. Why have you not listed any of this? So he files the bankruptcy in 2023, December. And this was, by the way, the assault. John DeJohn was security guard at the high school in 2015. So caused when Sanders elbowed and continued to hit Darjan during the altercation. Failed to appear in court, which, you know, stupid. Why would you do that? So that is just. But why does conduct come back to bite you in the ass? Here's why. It's when you go about buying Louis Vuitton bags, expensive chains, and you try to just scale it back. But you have that history out there, the trustee's going to see it. Goes out publicly and says there's 75,000 in his bling box, but then says, I don't know where it is. It's not mine. I don't own it. His attorney amended the value of the assets. Let's actually look at this crap, because this is driving me fucking crazy. The attorney amends the value of the assets in December to remove the jewelry because, quote, it is on loan pursuant to an NIL deal. Okay. Ostensibly, there's a document that says, here's a lending agreement. Just what the hell? And this, usually, I don't really say that a lot of these news reporting gets a lot right, but this one I will agree with. Sanders might need a refresher and some good advice. If you're going to file for bankruptcy, disclose all that you own in court. There's no room for guessing or allowing errors to sink your case. Also, there are certain things you can't hide and should be forthcoming about right off the bat. Yeah. Sanders might be in serious trouble by failing to disclose the assets. A Colorado-based attorney reviewed the court documents and told Buff's Beat hiding assets from the trustee is a crime. Also, he could be cited for contempt of court and disobeying orders to disclose. This attorney in Virginia is telling you the same fucking thing. Yeah. Why are you playing games with this? This ain't going to work out for you the way you think it is. It's really stupid to do. Why are you doing it? We're dumb. So let's take a look at where everything is right now. Because as it stands, we have a bunch of things that have been filed in the damn case. 10201, 10202. There we go. And initial disclosures. Open those documents and share that screen to get this one down off the screen. And go ahead and present this one. Share screen. Why are you not popping up? Come on. It's up. Hello. Where are you? No, I said open. I said open these. I didn't say don't open those things. I said open them. Okay, let's embiggen. Make larger. Voluntary petition. You know what's cool about these is usually they're bookmarked. Aha, it is. God, I love federal court. Let's see. What does he disclose as far as property? This is his original filing. So he got the Mercedes AMG, says 75K. Cool. Household furnishings, 10,000. TV, computer, printer, workout recovery equipment, clothing and shoes, necklaces. Let's see. Deposits of money, Wells Fargo, brokerage account. Then there's the account there. Now, this is the interesting part. Stock and interest in unincorporated and incorporated entities. So Big 21 LLC, SS 21 LLC. But he doesn't know the value of it. No clue. No clue what assets they have or whether it's valued at anything. Not a damn clue. Sure. I buy that. Why not? Any royalties owed to you? Nope. Didn't disclose any? Cool. I buy that too. Creditors, who'd you list? Colorado Department of Revenue, $0. Notice purposes. IRS, $0. Notice purposes. See, this is the IRS going to be curious about some of this stuff. John Darjan says 11 million, so he undervalues the claim, personal injury lawsuit. But you got Utica, 214, Visa, 0 on the credit card. Not a whole lot there, right? Income, what does he list? He is employed as a student. So for income purposes, this is the part that pissed me the fuck off. Income purposes, this young man who we know is receiving substantial income. Wages, salary, commissions, 0. Oh, look, 50,000 a month. There he goes. He lists 50,000 a month in income. Okay. So you have the income. So why is this not a bad faith bankruptcy filing? Oh, because he's listing all of these payments, because, it's completely legitimate to spend $2,000 a month on food and housekeeping supplies for a single person household that's a college student. And it's completely legitimate to have $2,292 a month in a car payment. So he has $40,000 in net income. So again, why are you filing Chapter 7 where this should be a denial of discharge because you make above the median income? What did you state your median income was? Calculation of current monthly income. Oh, you didn't list anything. No, you didn't. Did you really? See this little part here? By signing below, I declare under penalty of perjury the information on this statement and any attachments is true and correct. Okay. I don't see any income disclosed. And that would include this one. Income from all other sources not listed. I don't see any. Maybe I'm blind, but no, I don't see any. Oh, you know what? He doubles down. Hang on. Because we have this. Statement under penalty of perjury concerning payment advices. I, Shilo Dion Sanders, says other. The debtor does not receive pay advices for his stipend and is otherwise self-employed, does not receive pay advices. Oh, so we don't have verifiable amounts. Cool. Because that's logical and that makes sense. Why not? That's totally fine. So the trustee obviously gets a little bit peeved about this, and the trustee files. Where was this? He amends the schedules. So he amends the schedules. What do we list? So we correct it. Let's go ahead and X that one because we don't need that anymore. Corrects it and says, Department of Revenue, IRS he owes $130,000 to. Cool. Pre-petition taxes, contribution for salary, $11 million for that claim, $214 for that claim. Use credit card. All right, so it doesn't really change much. $11.2 million. That's what he's saying he owes. But he also lists in this one, I think he lists a house. There's the Mercedes furnishings. Cool. What did you change? What'd you modify? Robin Hood. Oh, it's only 217. It's not all of it. I don't own all of it. I don't own the 300,000. It's 217. So we're reducing it. And we have a security deposit at the place where we live. Okay. All right. That's all you got. Right? No problem. Sure. Why not? Trustee gets pissed. Trustee's like, we need information and we need more. So the trustee goes and says on February of this year, said, I'm the Chapter 7 trustee. He's an athlete here. I've retained an accountant and auctioneer to basically do an assessment of what's going on in this fucking case. The auctioneers made numerous repeated requests for access to the debtor's premises. Well, that's kind of funny because you say you don't own shit, but then when the trustee's like, let me into your house to see if you own shit, you just kind of say no. That's not how that works at all. Some of you might remember Warren Sapp, another famous football player, filed Chapter 7 bankruptcy and had to turn over a lot of his shit. Now, he just magically disappeared some Super Bowl rings. My God. You really think that the trustees, you really think that we don't know how to find this stuff? You think that we have never seen any of this? Like, you are now the smartest person in the world. We're not going to find it. Inspection of the premises is necessary. Yes, it is, to determine if he has any assets. You're right. It's given us no reason why we can't do it. Also true. The debtor at the meeting of creditors testified that there were non-disclosed automobiles listed in other states. Well, that's a problem too, because you have to disclose them. Also requesting, give me your tax returns, which you actually have to turn over by fucking statute. Disclosed jewelry on his initial schedule of $75,000. In the amendment, he says, nope, not there. At the meeting of creditors, he says, no, I didn't own it. It was loaned to me for promotional purposes. Well, then why did you state under penalty of perjury that you did? Trustee wants an inventory, including the name, telephone number, and addresses. Tell me who owns the shit. And by the way, give me all the contracts that you have, people that either owe money or you owe money to, etc. I've talked about this before. The filing of a petition to commence a bankruptcy case creates an estate consisting of all legal or equitable interests of the debtor in property. Everything you own. This is what the debtor is supposed to do and shall do. And you know what happens when you don't do this shit? You're violating the law. Debtor shall, if a trustee is serving the case, surrender to the trustee all property of the estate and any recorded information, including books, documents, records, and papers relating to property of the estate, whether or not immunity is granted under Section 344. Basically, whether you claim it's exempt or not, you give me the information. And I have made this comment before. Bankruptcy is a serious matter, and when one chooses to avail himself of the benefits of Chapter 7 relief, he assumes certain responsibilities, the foremost being to fully disclose his assets and cooperate fully with the trustee. You have to turn this shit over. Period. End of story. Done. So that fight is still ongoing. But we also have this fight, an adversary proceeding. 2 adversary proceedings are actually commenced. So this one is filed by John Darjan, who's saying, deny this debtor a discharge at all. So he filed 2. One said, my claim is non-dischargeable. Like, make my claim special because he intentionally did the thing. This one is, make sure that nothing is discharged. And some of these claims have survived, some of them have not. But what we basically have is a background of the assault, history of discipline problems leading to the assault, and the bankruptcy filing. So deny all discharge, give me my fees and costs, do all of the things. Where is the background of what took place? What did Shilo Sanders get accused of doing, and what did he do? So the lawsuit was filed June 20th of 2016 in Dallas, Texas. Filed a lawsuit because of her horrible and vicious attacks committed by Shilo that occurred on September 17th, 2015. He was represented by counsel. So when Shilo didn't appear, he was represented by counsel. He had an attorney there. He just didn't show up. For example, counsel for Shilo defended the deposition, brought motions for leave to file third-party actions, appealed the associate judge's decision denying a motion, filed motions to exclude expert testimony. I would call that meaningful participation in the underlying lawsuit. In an effort to escape the liability and accountability after diligently contesting the lawsuit throughout and until the trial, Shilo simply ignored all notices and refused to appear for trial. You know what a judge does when you don't do that or when you just don't show up? The judge enters an order, enters a judgment against you based on the evidence that they're allowed to present without you being there because you waived your right to present any evidence on your behalf. So they then go about trying to collect everything against him. So at the time of the incident, Darjan was employed as a security officer at Focus Academics and held the position since 2011, so 4 years. Shilo was a student at AAA Academy, the Focus Academics High School. Shilo was 15 years of age at the time of the incident. What did he do? Turned 18 years on February 9, 2018, well before trial. Retrieved Shilo. Shilo was playing a dice game. Okay, so here you go. At approximately 10:45 a.m., Darjan was contacted by Academy principal that Darjan was going to lunch. Ms. Green asked Darjan if Darjan would retrieve Shilo. Shilo was playing a dice game in the classroom and interrupting class despite the teacher's request for Shilo to stop. So, disrupting class. Darjan arrived in the classroom and waved Shilo to come with him. Shilo stood up, cursing, and stated, "Man, I just want to know the motherfucker that snitched on me." Classy 15-year-old. Darjan then escorted Shilo to the office of the disciplinary officer at the time. En route, as well as arriving at the disciplinary office, Shilo was cursing loudly and repeatedly, asking who snitched on him. Because Shilo acted disruptively in the disciplinary office, Coach Hart instructed Darjan to take Shilo to in-school suspension ISS, which he probably did. 5 minutes after leaving Shilo at ISS, Darjan received a call to return to ISS to escort Shilo back to the disciplinary office because he was making telephone calls against school policy and otherwise being. So he's in school suspension, picking up his phone, calling people. He was uncontrollable, shouting obscenities and cursing at school staff, all while refusing the ISS teacher's numerous requests to cease acting out and to stop talking on the telephone. Then brought Shilo to his office because Hart was out to lunch. While in the office, an assistant to Shilo's father, Dion Sanders, came to. So one of Dion's assistants came into the office. The assistant had Dion on the phone. Oh, God. It's about to get bad, isn't it? The assistant had Dion on the phone when the assistant arrived at the office and upon entering passed the phone to Darjan. Dion heard that Shilo was calling Dion's ex-wife. Oh, God. Oh, no. Family drama has entered the cat. Oh, God. Dion heard that Shilo was calling his ex-wife, Pilar, and demanded that Darjan stop Shilo from contacting Pilar by Darjan seizing the phone. So a parent instructing somebody to seize the phone. Dion and Pilar were going through a public and nasty feud in family court over divorce and custody matters. God, man, this is no kidding. Dion repeatedly asked Darjan to take the phone. Furthermore, using telephone was a violation, so this is the right to take the phone. Darjan repeatedly and calmly asked Shilo to get off the telephone and turn it over to him. Shilo refused every request of Darjan to relinquish the phone. Shilo then abruptly walked out of the office despite being told not to do so. So he's like, no, I'm out of here. Dion told Darjan, do me a huge favor. Oh, God, you're my brother in Christ. I need you to go get that phone. As soon as you get the phone from him, give me a call back. This is fuck. Darjan followed Shilo in the hallway and suddenly, without warning, Shilo violently attacked him. Darjan was telling Shilo he could not use the phone, attempting to take the telephone from Shilo, and Shilo was snapped and took his elbow and slammed it as hard as he could, super hard, right at my chest and then drove it into my neck. I fell back. And then I fell back. My mind instantly went into restrain from hitting my kids, any kids, because we had about 7 kids right there from hitting me again or him hurting himself again. So I come to and I come back up. As I fall back, I come back up. I feel 2 more blows right at my chest and my neck, and boom, boom. Oof. That came to an end. He was on the ground, immediately began feeling tingling sensation, equilibrium was off. Yeah, you get jacked up in the neck. Witnessed by multiple employees and recorded by video surveillance. Well, that'll do it. Witness punches the face. Lost control. Oh, Darjan lose control of his bladder. And that's not an inconsequential injury. 911 gets called, taken to the hospital. Prior disciplinary problems. Permanent debilitating injuries. Oh, we had neck injuries. Okay. Oh, shit. Cervical spine surgery. Yeah. Okay. Wow. As of February 19, 2016, Darjan was still having ongoing left neck, shoulder, back, shoulder blade, and left upper extremity, back as well as left lower extreme pain. So a whole lot of pain. Went through a bunch of therapy treatments to get it treated. This is the spinal stuff, man. Spinal stuff is so. I mean, there's treatments that can help. There's treatments that can't. Spinal stuff is so fucking complicated. Epidural injections, severe pain, neuropathic pain, spasms, severe numbness, permanent spinal stimulator, amongst other treatments and emergency room visits. Must continue to wear adult diaper. Oh my God. There's the workman comp. So because of the injuries, he wasn't able to return to work. He must continue to wear adult diapers due to the incontinence caused by his spine and neck injuries and continues to suffer from spasms, sharp pains, weakness, and numbness on a daily basis. Welp. Yep. Shilo files for bankruptcy. These are the assets listed. Items not disclosed. So what did he not show? Shilo twice failed to itemize and give value to the individual items of personal property. Made no attempt to cure deficiencies. Initial schedules claimed 75,000 jewelry. Then he says, no, not there. No description of jewelry was provided. He's known to possess skiing and snowboarding equipment and or gear. Known to own and possess music equipment, which is omitted. Twice indicated the amount of his clothing and shoes is unknown. As all other asset categories failed to make any kind of categorization of itemization of his clothing and shoes. Disclosed the ownership of Mercedes, but at the meeting of creditors says there's at least 2 other cars. Contrary to the schedule, Shilo was admitted acquiring vast amounts of high-end and expensive clothing. For example, on his YouTube channel, there's the Louis Vuitton comment. Schedules admit the Louis Vuitton, all of the above. No mention of designer brands plastered all over his Instagram, TikTok, etc. So they disclose the existence of the entities, but they don't say anything for the value or anything that the entities own. Any of the contracts he has. Shilo also fails to address the schedules, the NIL deals. So these are the some that they know about. 9/28/2013, Instagram paid partnership from Tint My Ride. 9/13/2023, paid partnership from KFC. You got paid partnership with KFC, paid partnership with MetaQuest, KFC, the Sanders family, KFC, Sanders family, KFC, paid partnership with TurboTax, Champ Sports, Oikos Yogurt, Porsche. Oh, he's paid partnership with Porsche. Paid partnership with Actively Black, Kinley, paid partnership with Instagram Cloud Gaming Chromebook. Didn't mention any YouTube ads, Instagram threads, and anything like that. Nothing. Nada. Nothing mentioned. This is a clusterfuck. All right. So that was everything there. The case is ongoing right now, and these are the initial disclosures. People that have information and knowledge of these things going back to these dates. And the most recent status date that we have on this is some of these claims are resolved, some of them are not, but they are largely outstanding. So we don't have turnover of property. We're still looking for the property, still trying to figure out where it is and what it is. We have partial agreement on getting some of that property, and we have a complaint that's going to be scheduled for trial. This is just a whole lot of what the hell. And I would not be surprised if you have some inquiry by the U.S. trustee at some point in time saying, hey, so you filed for bankruptcy and you filed for this relief and you were required to state under oath that certain things were true or not true. And hey, maybe you didn't do that. So we'll just have to see where that goes. But I wanted to bring you guys up to speed on that one because it's a case we haven't talked about yet. And I hadn't seen a whole lot in the news about it. So I wanted to just talk about it briefly, get that caught up. So yeah, he was 15 at the time. There's a certain part of it where there was a claim that's in dispute now as to whether his minority status at the time of the incident actually, whether there's any exemption or protection for that status going forward into the bankruptcy. What ends up happening though is that when a person attains 18 years of age, right, the judgment was already entered. So you already have that judgment binding. Is there still protection after they've attained 18 years of age and have property and earnings of their own? Or should they actually have to start paying that judgment? So that's subject to debate right now. We'll see if we have a ruling on that within the next few weeks. So, I mean, case is a mess. And the name, image, and likeness stuff. Crazy Cat Queen, yeah, we can follow it. Can we please follow this case, Rob? Yeah, I'm following that one. I am. I absolutely am. I'm too interested in what's going on, so I put an alert on the docket report there. Yeah, I saw it, Benjamin. I'm going to fly through. I have to fly through some super chats, get caught up, and get out of here for the evening. So let's go ahead and do that. Super chat or swoop to super chat catch up, and we will be wrapped for this evening. Look, we covered a lot of topics. Whole lot of. I played swoop again while I was talking. A whole lot of topics we covered. So we did a lot this evening. Thank you guys for being here during the entire time. Crazy Cat Queen forgot to brag on my hubby. After 2 years of listening to me talk LawTube on a daily basis, my husband started paralegal school this week. Congratulations to the hubby for doing that. That sounds phenomenal. Love that idea. Oh, I never ended the poll. Hang on. What was the poll? End poll. What, if any, portion of the ex parte transcript will be made public? The poll results after 1,600 votes, partial, 86% redacted, got 36%, none, as in fully redacted, 33%, partial, 25% redacted, got 16%, and full, as in all redaction or full proceedings, we get everything, 13%. 13% of you guys have a lot of faith that we're going to get the whole transcripts. 13% of you have a whole lot of faith in something that I just don't. So as we get super chat catch up, please remember to like, subscribe, do the YouTube things. It really does make a whole lot of a difference to the channel. And I really do appreciate you guys being here. And thank you to Ian for popping by, and please wish him some very fast healing. He's going through a bunch. Man, he's got deadlines coming up. So I hope he recovers quickly. And he wants to cover Baldwin. And that's coming up on July 8th, 9th, and 10th. Beginning of that trial. I think those days are the beginning of jury selection. Holly, just sitting here working on another scratch art project. Love FNF. Thank you, Holly. Glad you're here and enjoying the art project. Alex Kane, TIL comedian Bill Burr from Canton, Massachusetts. Interesting. Bill Burr makes me laugh. Baby Gator, I think EDB is traveling on Monday, so of course this won't be resolved until then. No chance. Gen V, you two are a great distraction from my husband's deployment. I learned so much from you and EDB. Gen V, I'm right there with you. Hopefully you will have a speedy return of your loved one. And that this time apart will only strengthen the love and bond between the two of you. Those deployments are tough. And I've never understood how families can actually make it through those. I'm remarkably impressed by everyone that can. Purple Dragon Air. I also needed a distraction tonight. I got the news that my father is being put on hospice care with a DNR due to complications of liver cancer. Purple Dragon Air, I'm very sorry for that. And we repeat the refrain, fuck cancer, and the horse she rode in on. So my thoughts and prayers go out to you and your family. Britt Cormier, There is no such thing as a dumb question, except for if not what the state says, then what happened? Anything or everything but that happened. Oh, if it's not what the state says, then what happened? But it's a natural question people ask, even though the burden tells them not to. Some people can't create that wall. Like they can't put this is my instruction and I must follow that instruction regardless of my feeling. It's a very difficult thing to ask some people to do. So it happens. Clemson's victims, objectively justice driven. Twitter, Sarah Boone. We shall see. Raven 254, I think defense has put on unnecessary burden on their case by declaring they could prove a conspiracy. Thoughts? I made my opinions on that one kind of earlier in the stream. I think that they bit off a bunch. It's the only part where I kind of question how far they wanted to go with that. Nikki Lewis, thanks for being a member for 9 months. What, if any, side question we sort of on? I meant that the court shouldn't pressure or guilt the jurors into making a decision because of all the effort put in by the government. That's a fair assessment and true. Actually, I believe they shouldn't. Nightcat, would y'all consider maybe recapping the wildest moments as though you're on a 2 a.m. butt dial and only have 22 seconds or minutes? Brainworm. There's not enough time. Case has been pretty remarkable. WW, the Reed trial is happening in the same courthouse as Sacco and Vanzetti were tried in. I know that. The courtroom where the part of the jury couldn't see the witnesses stand, that was in that courtroom. I know. I love it. I love the history of that courthouse. It's also why the AC units are pumping at all times. Thank you for commenting on that. Adrian Angevine, hello, gentlemen. Love you both. Rob, I really enjoyed your debate with Joe on Wednesday night. Could we grift a little to get him over 100K milestone? I did. I jumped on with Joe. I called in because I was listening to him rant about something, and I was bored doing laundry and ironing a shirt. So I called into his stream, and we just had a discussion because he was very pissed at the Supreme Court for something. I was like, hey, give him some grace. Just to give him a contrary argument that could, you want to argue with somebody who actually presents the argument properly. So Joe Neerman, good logic. Covers some political stuff, so that's a warning. But I will say he's a fair guy. He's a funny guy, nice guy. He stayed here at Law, Lumber, and Lodging once. Good man, though. So he's very close to 100,000. If you guys want to check him out, please do. Mano, Wagstaff. Seriously, guys, go make something. You'll feel good. I agree. The Squid, the person that said hours of service rules is about safety is partially wrong. The daily has rules. Daily hours of service rules is about safety. The weekly hours of service rules was to force companies to allow truckers time off. There's other ways to do that. Interesting observation. Thank you, The Squid. Renee Smitley, Bev appointed by governor in Massachusetts. There you go, not elected. Misty Harris, would it have been better to have a venue move? They weren't going to move it. I don't think there were grounds to move it. The jurisdiction where you commit the crime, the people that are there were injured by that crime, they have the right to enforce it, barring exigent circumstances or significant circumstances. Kirsten Berry only asked about officer because it's what I heard. It's fair. I don't blame the question. I just don't know enough to speculate on it. Happy Annie, lost my husband and mom. You all helped so much. Thank you. Happy Annie, I'm very sorry for that loss. I hope that the recovery period in your life is going as well as can possibly be expected. Give yourself some grace. Try to find happiness where you can. Never forget either of those individuals. Keep them close to you. South Texas, co-counsel Elaine or Lolly? Neither. That's in regard to Sarah Boone, I assume. Angie, from what I heard in a weird video statement Lolly's boss put out, the boss, is the one that pushed for the trial. I've heard similar reports. I don't know, though. Lady Fang, early drink fund for her trial. Sarah Boone, she will never be happy with any lawyer because they won't tell her what she wants to hear. Well, she doesn't have one now, so she's yelling into the ether. Jenny, we need Wood Daddy and Crash Daddy stream together. If y'all can put me in contact with either's Wolf or Rentschler, I imagine I would have a lovely conversation with both of those gentlemen. Ms. Nomer, why did defense only give one possibility? Would it be better to give multiple possibilities? This is in regard to Sarah Boone or in the defense of Karen Reed. In either regard, when you start throwing everything at the wall, the jury starts to see you do that. They don't like it. They see you as just obfuscating or making things very muddy when it's not. So it's best to stick with one thing and not change. Shannon, S77, I was a juror in a federal case that was 10 days. My notes consisted of only published evidence and the number letter that was assigned to it. This helped deliberations tremendously. There are ways to take notes, and good note takers are the best kind when it comes to anything like that. I wish that there was a bit more of an instruction on notes to be taken, but again, is what it is. Lady Fang, an expert with 130 hours. You mean Trooper Paul? I don't know. Or I don't know. Maybe, maybe not. Tina, the internet would rather have every person that's ever been accused of anything, guilty or not, locked up for life. Internet's internet. It's going to internet forever. Sue Diaz, thank you very much. And thank you very much again for the super stickers. Laura Lee Anning, late to the party, but the blurb you read from Commonwealth Judge Rules is out of order. There's been no dynamite charge yet. You two are a great combo. I didn't read them out of order. The dynamite charge. So the dynamite charge. No, I read the Allen charge, which is what we commonly think of it as. Massachusetts has a very specific charge, the TUI charge. I read the Allen charge to give context for what we're used to, and I read the TUI charge to give an understanding of what is supposed to be read in this case if it gets to that point. We don't know if we'll get there. Alice Ann, the anthropomorphized crime scene spoke to me is the new. I use them synonymously in my humble opinion. The crime scene speaks to all of us, Alice Ann. I don't know how, but it does. Ian Paler comes now to the appeal. Oh my God. Caitlin Nadine, here's the last $5 from my give a fuck fund to the Canton Police Department. I no longer have any to give. I don't really blame you. Angie, chat is extra bay today. Chat is bay every day. Teresa Morrow, why has no one mentioned that Jen McCabe told 911 they had turned John over? Everyone testified that he was found on his back. There are so many conflicting statements. The conflicting statements for me was a big issue in this case. Just is. Red Solo Cups of evidence. How do you actually find and pick a good lawyer? Interviews, meetings, and past experience. So talk to other people who have been represented to get their impressions and feelings. You would be surprised. A lot of friends will very openly talk about their experience with lawyers because they either hated them, they loved them, or they were impartial, but they're always willing to tell you pretty strongly one way or the other. Cootie Patootie or Cootie Pootie Tootie. Thanks for the content. I make baby hats to donate while watching. Got 3 done tonight. Thanks for both of you. Make the world better. Thank you, Cootie. Pootie Tootie. See, 3 baby hats, 3 names. Glad and thank you for donating those. That's amazing. Sandy, thank you for the memberships. Joshua, thank you for the memberships. Why are my mods gifting memberships? They just, why? Guys, I'm wrapping stuff up. Don't make it longer. DJ Taint, did someone say Taint? DJ Taint, you were not summoned. I mean, kind of where, I guess. I don't know. Unintentional. Aaron Patterson, I so look forward to FNF. Thanks for the content. Thanks for being here, Aaron. Much appreciated. Michigan Farm Boy, wasn't the fact that he didn't previously seal the ex parte meeting why you said there shouldn't be a show cause. Always enjoy you and Runkle. Yes, that ex parte was not sealed. No one was ordered not to say anything about it. So how do you show cause someone for saying something about it? You can't. So we'll see that. That's being argued this coming week as well. Feral Dragon, how can we talk about how well all parties are sleeping in Young Thugs at some point? Can we talk about how well all parties are sleeping? Oh, they're all sleeping at some point? Or how well they're sleeping at some point? I don't know. But that trial it's been 99 days. 99 days. Elf Liggins Glanville is practicing Calvin ball, not law. Joshua, thanks again for another great FNF and have a wonderful weekend. Everyone, thank you, Joshua, and thank you for that lovely message in the chat. LR Dub. Hear me out. KR bench trial. Hear me out. KR bench trial. How could Bev possibly not see the reasonable doubt, election or no? Bench trial, I don't know that you would have gotten half of the evidence in. Judges are more discerning in what they will or will not hear. So I don't know. Crazy Cat Queen, Shilo was in a Google commercial with his brother. So you know he has at least one NIL deal. He has at least one. Multiple. Millions of dollars, I imagine, flow through that NIL. Krista Bolster Robichaud, new member, single mom to an amazing 19-year-old son with ASD. And because of you, Runkle and EDB, we are awaiting an acceptance letter for University Mechanical Engineering. You all are making Neurospicy a superpower. Thank you. Krista, thank you for sharing that. And congratulations. That's a tough job. Way to go. Thank you so much for sharing that. I take no credit. That goes to you and him. Congratulations. Beck Edwards, Oz away from Mass. KR, Young Thug, Sandra Birchmore. Just stay away, I guess, from Mass. I'm not driving through there in a little while. The world wonders, this is how you get Al Capone. Blessed in Texas, my birthday is July 5th, a U.S. holiday this year. Happy birthday. Hope you enjoy it. Melissa asks, what'll last longer, Haas long, or what if any? Both. We'll use them synonymously. Crazy Cat Queen, Shiloh Sanders was brand ambassador for Porsche, had deals with TurboTax, Champ Sports, and Spray Ground. And Google, he also needs to get a retroactive F in all math classes. Can you believe, dude, is a graduate in graduate school at Colorado University. People make mistakes when they're younger. This mistake happens to be a very egregious mistake that resulted in some significant harms to a person who's going to live with those harms for the rest of their life. I'm willing to give grace on the mistakes made by people when they were in a younger phase in their life. What I'm not willing to do is when people hide assets to skirt their responsibility for the repayment, whether it's time or whether it's money for the mistakes they've done. So that's the part about this case that's bothering me a lot. Wendy Wilkinson, why weren't the parents held liable for the cost of the minor? I'm gonna have to look at that another day. My brain is a little bit brained out. It's almost 1 a.m. my time, but I will look at that because I know that's being argued. Fiona W, thanks, Rob. Always great start to my Saturday. Thank you, Fiona. Baby Steps 22. I'm very late. Was at a professional women's soccer game with my daughter. Awesome. We'll catch up and replay. Love the beard trim. Everyone have a great weekend. Thank you very much. Very kind of you, Baby Steps. Amy Griff, thank you very much. I undermeant what you stood. I got that reference. That was good. I undermeant what you stood. Solid. Celebrating my birthday vicariously tonight, 7/5/1976. Happy birthday to you. Absolutely happy birthday. Hope you have the best birthday. Hunk Banana, no, I made a mess. I don't feel better. Well, try again. I know you're teasing. You always do. Amy Griff, fucking Afghan. About to go to yet another memorial. This time it's something renamed in my husband's honor. I want it to end so I can move on. Maybe I'm very sorry for everything you've been through and that loss. I'm sorry for that. So, Mama Betts, any update on Maya? Not that I have seen. I can check that out for the next time when we go live. I will go ahead and take a look at that case again, see where everything stands. But for this evening, we are 4 hours in. It is nearly 1 a.m. my time. 4 hours, 14 minutes. I didn't want to go all the way to 4 hours, but you know what? We did a lot of topics. We did Chevron Deference. We did Karen Reed update. We did Sarah Boone. We did Judge Glanville, and we did Shilo Shilo Sanders. 5 full case updates. 5 case updates. I don't know if I've ever done that with this amount of time. So I'm pretty happy with that. Okay. So going to go ahead and say good evening to all of you. Hope you have a wonderful, wonderful weekend. Enjoy every minute of it. Get outside, touch some grass, go make something. You'll feel better. Hug your families and your loved ones. Keep them close and tell them you love them. Whether they're with us now or whether we're celebrating their presence in a great hereafter, wish them all the love and speak with them often, frequently, and with every bit of passion you can muster. So cheers to all of you. My well wishes to a very pleasant weekend. Enjoy the summer. And reminder, I will not see you this coming Friday, that being Friday, July 5th. But I will be back the following Sunday, or the following Friday. Did I say Sunday or Friday? Friday, July 5th. Friday, July 5th. So Friday. But I'll see you Friday, July 12th. So cheers to all of you. And without further ado, like I said, go make something. You'll feel better. Catch you next time.